This is the September 28th, 2018 meeting of the Zoning Board of Appeals, which I'm calling to order now. And the first item on the agenda is an application by 68 Turnpike Road. It's an appeal of the building inspector's determination that the applicant first has to obtain a report from the planning board before the building inspector will accept an application for a special permit and a use variance to build a digital billboard. First, one matter. We have one vacancy on the board right now because of Mr. Eagle's resignation, and I have appointed Mr. Walker, Jeff Walker, as the senior alternate to sit on this matter. And there is an issue I want to raise about the current composition of the board, which is that Mr. Bartolini, I'm aware that your business is a direct abutter to the applicant in this case. I think that raises a very serious question about whether you have a conflict of interest and can sit on this matter. I would strongly advise you to recuse yourself. I think that it would be best for the board. There wouldn't be any questions about your motivations in your actions on this, and I would very strongly ask you to consider that.
Could I weigh in?
Excuse me, sir. I've filled out a form originally to not sit on this because I am an abutter and everything. The only issue is that what's presently in front of us has nothing to do with the application of the sign. The application that's in front of us tonight is strictly for a regulation and bylaw of the zoning board. If you don't want me to sit, I'll excuse myself.
Thank you, and I appreciate it.
I don't think I have to because
I don't mean it as any sign of disrespect whatsoever. I just want to let you know that, in recent months, there's been a lot of questions about transparency on the board and things like that, and I think this will help alleviate those concerns. So I appreciate it.
I filed it with the state 2 weeks ago.
Thank you. Mr. Pizzoni, do you
Mr.
wish
Chairman,
to be heard?
yes, if I could be heard.
Yep.
First of all, the petition that's before the board tonight is really about administrative process of your board and how you handle applications. It has really nothing to do with the merits of the variances and special permits that will be brought, which at that time I would think Mr. Bartolini would have to step off because it has to do with a property that's directly adjacent to his. I do believe he's been chairman, and I've been on this board for quite some time, and his input may be important or relevant relative to my petition, relative to whether or not we have to go to the planning board before you take in an application.
I understand the distinction, but I don't think that, and again, this is my own view, and also thinking about issues about transparency, appearance of conflict of interest. I just think it's best if,
Okay,
with
in that
no sign of
regard,
disrespect.
though, because
Yes.
I'd like to say something else, I'm going to ask you to recuse yourself tonight because I watched the planning board hearing of Monday night, and I understand from the conversation that the dialogue that was going on there, Mr. Morris, the chairman, said that he had had several conversations with you about this petition, which is clearly tainting in its ex parte outside of the confines of this room where those discussions are supposed to occur. So whether or not, I don't know what was said, but I think there's a sense of potential impropriety. The second component of that is they actually sent a letter, which I got a copy of today, that speaks to the merits of our applications that aren't even before you or before them yet. So my client's due process rights have been severely interfered with here, and there's going to be some real concerns going forward if we don't take this process seriously and don't have ex parte conversations, don't let a vigilante group come in and rile up Mr. Morris's board so that they write a letter where there's been no presentation made to them.
I share your concern on that, and I do want to assure you that I did not request that letter be sent. I did not suggest that they send any letter. My concern here was that, this is a matter there's some joint jurisdiction between the planning board and the ZBA in this, okay? I saw their agenda. I saw that this matter was on the agenda. I asked Mr. Morris what had been filed, what actions we're taking. what they were doing, okay? So I don't think any of this crossed the line, all right? And I can assure you that I am open to your presentation. I haven't made up my mind. I understand that right now, the decision is just what application should be accepted. It's not, we don't even have a special permit or a use
You're right.
variance.
You don't have a special permit, and you don't have a variance request because they were not accepted when they were brought to be filed because of this position, and that's why we filed this petition.
And I think you have a valid concern there that the planning board issued this letter and you weren't provided an opportunity to comment
I
on it,
do.
and
I-
it's not
I-
even on any application that's been filed.
I appreciate that, but the fact is, we have on the record, and I'm talking, as a citizen of the town, too, there's been discussion between two chairmen of two different boards, separate boards, which was acknowledged at a public hearing the other night about this petition and project. So I'm concerned that it's tainted from my respect and from your respect. So I think, in fairness to the applicant in the process, that you would have to recuse yourself from this hearing as well.
I've considered it, and I've decided that I'm not going to recuse myself
Okay, well,
because
I
I
would
feel
just
confident that I
like-
can continue to be unbiased, and I'm open to your presentation, and I'm open to the relief that you're seeking.
Okay. I appreciate that, and believe me, I was looking forward to my first hearing before you as chairman to be a little bit less adversarial. That's up to you, it's your decision. I just wanted on the record that, I do object to it, and on
Sure.
behalf of the applicant, which I have to, okay?
Your objection is noted.
Okay.
So what I think we should now do is.
Actually,
Yes.
I also want to note that there's been a question about a potential conflict of interest on my part brought by a citizen with regards to the fact that in my professional life, I've worked with Cornerstone Engineering in the past. I've contacted the state ethics attorney. I've discussed it with them. They do not believe there's anything other than a need to file a disclosure in regards to the fact that I've worked with them approximately two to 3 years ago. I've done that. It's been submitted to the Board of Selectmen. I do not believe it has any impact on my ability to be impartial and hear what you have to
Just for
say.
clarification, did you say Cornerstone, the engineering company?
Yes.
Because they're not involved in this petition.
I
other than-
understand they're not
other
involved in
than
the
they
position,
did-
but
They did a survey
There's
for
a site
the-
plan
Right.
that has their name on it.
Right.
It got brought up.
Yep,
Again, in the interest of being transparent,
I appreciate that.
I understand it has nothing to do with the petition you've requested.
Right.
But in regards to your overall plan and everything else, it was brought up, it's been discussed, it's been disclosed, and again, I do not believe it poses any issue in me being impartial on this.
I have no problem.
And before we go, now that we have, to have a full member board, I want to appoint Mr. Williams to sit on this
Sure.
matter, too.
Yeah, on a matter of levity, I'd like to point out that I'm deaf.
Okay, well, I think how we should proceed is Mr. Pizzoni will allow you to make a presentation, and if your
Sure.
client wishes to speak too. Is that your client here?
This is Dominic Serra, actually. Dominic lives in town.
Okay.
He is an agent for Lamar.
Okay.
And helps them find sites.
So you can make a presentation. Pardon me?
Yeah.
Yeah, why don't you read the public hearing notice?
Lamar Central Outdoor LLC, 6 to 8 Turnpike Road, Southborough, Mass. The Board of Appeals of the Town of Southborough will hold a public hearing in the Thomas J. McAuliffe Hearing Room of the Southborough Townhouse, 17 Common Street, on Wednesday, September 28, 2016, at 7 p.m. with regard to the appeal of Lamar Central Outdoor LLC, care of Capital Corporate Services, 44 School Street, Suite 325, Boston, Mass. The petitioner is appealing the building commissioner's determination that the applicant must first obtain a report from the planning board before he will accept the applicant's applications for a special permit and use variance to erect a digital billboard per section 174-11E4 signs. The Board of Appeals will not act on any special permit or variance application without first receiving a written report from the Planning Board. A copy of the application may be reviewed at the office of the Building Department at the Townhouse during normal business hours. Andrew R. Dennington, Chairman.
And we also have a letter that came in from the planning board on this. Do you want to read into the record now? Yeah, there's actually two letters. Yeah, sure. Thanks.
Great, thank you. September 27th, 2016, to Mr. Andrew Dennington, Chairman of the ZBA, Zoning Board of Appeals. Mr. Andrew Dennington, Chair, Zoning Board of Appeals, reference 6 to 8 Turnpike Road, Lamar Central Outdoor LLC, appeal. Dear Mr. Dennington and members of the Zoning Board of Appeals, on September 26, 2016, the Planning Board voted to support the building inspector's decision of August 16, 2016, denying the applicant a building permit. In that letter, Mr. Robidoux stated, I have reviewed your building permit application regarding installation of a digital billboard sign. At this time, I must deny the request for a building permit as it is not an allowed use and will need to be heard under a use variance and several variances and special permits respectively. He cited sections 174-11, 2, B, C, and D. He ended the letter with, please go to the planning board prior to filing with the Zoning Board of Appeals. On September 7, 2016, an appeal was filed by the applicant to the Zoning Board of Appeals, and it stated, the applicant is appealing building commissioner's determination that the applicant must first obtain a report from the planning board before he will accept the applicant's petitions for a special permit and use variance to erect a digital billboard, per section 174-1-4, signs. The Board of Appeals will not act on any special permit or variance application without first receiving a written report from the Planning Board. The Planning Board respectfully recommends that the Zoning Board of Appeals deny the appeal above and upholding the building inspector's decision. Sincerely, Donald C. Morris. And the next letter is dated September 27, 2016, to Mr. Andrew Dennington, Chair of the Zoning Board of Appeals. Reference 6 to 8 Turnpike Road, Lamar Central Outdoor LLC. Appeal. Dear Mr. Dennington and members of the Zoning Board of Appeals, the section of the code referred to in the ZBA's agenda for September 28, 2016, compel us to review the proposed sign during our Planning Board meeting on September 26, 2016. The board's review included the actions required by section 174-11E4, which are the following. 1, sign scale is determined to be reasonably relation to the development scale, viewer distance and travel speed, and sign sizes on nearby structures. 2, sign size, shape, and placement serves to define or enhance architectural elements of the building such as columns, sill lines, cornices, and roof edges, and do not unreasonably interrupt, obscure, or hide them. 3, sign design is in harmony with other signage on the same or just adjacent structures and provide reasonable continuity and mounting location and height, proportions, and materials. 4, sign materials, color, lettering style, illumination, and form are reasonably compatible with building design, neighborhood, context, and use. The Planning Board voted 5-0 that the design did not comply with each of the 4 criteria listed above and recommends that the sign be modified to comply with the sign bylaw. Please accept this as our written report as required by section 174-11E-4-5. Sincerely, Donald C. Morris, Planning Board.
Okay, so what I'd like to do, Mr. Brizzoni, is allow you to make a presentation, and then we'll open it up to questions from the board, and then we'll see if there's any comment from the public.
First of all, I'd like to point out that what is referenced in the letter that I just heard read about that you should uphold the building inspector's decision denying the applicant's building permit, I wasn't appealing that. That wasn't appealed and that wasn't before you, okay? The second thing I would like to ask is, I'd like to know what they reviewed at the planning board, since the application before you is just an appeal application which only had the zoning officer's letter attached to it, and there would be no plans for them to review, okay? And this is why I raised this issue, okay? The building inspector said, yeah, well, I need you to go to the planning board and get a review by them. And I said, I know I have to go to them, but I don't have a petition that's active yet because it isn't filed with you. I don't have a variance petition, and I don't have a special permit before you, which would have all my plans, so that we know when I go to the planning department, which was the intent, to talk to them about the petitions that were before you, the ZBA. And he said, yeah, I know it doesn't make sense, but that's kind of the policy. I said, all right. So I went back and I looked through your application procedure, your application rules and regulations, everything that you have out there that is out there for developers and landowners to file their applications. And nowhere in there does it say, you have to go to the planning board before we'll accept your application and put it into the process. You know, Mr. Dennington, as a lawyer, that the reason we have these rules is the clock starts to tick when we file these applications. And I know why that rule or obligation was incorporated into the zoning bylaws about having to go to the planning board to review the stuff, and they wanted it before we get through public hearing, so a public hearing isn't getting delayed and delayed and delayed, okay? Not that I think I was ever an offender of that, but had they taken my applications at the time we had submitted them, I probably would have been before the planning board last Monday night with a whole set of drawings, a whole set of diagrams, and explained to them everything there was to know about this project. Instead of them writing 2 letters like this, violating my client's right to due process, to come in and see them, and to come in and see you. Now, if I don't have an application pending before you, they could say to me, don't come back until you have an application pending before them. So, seriously, you know, they could say, we don't need to write this letter until you're before them. So, if you read your bylaw, it says you can't act. It doesn't say you can't accept petitions or start the clock ticking. It means you cannot act unless you get a report back for them, favorable or unfavorable, doesn't matter. You need to get a report back. That also infers that they're gonna respond in a timely manner as well. So there's an obligation on them. Let's say I went in, I filed, I went to see them Thursday, and they didn't send anything to you for 3 weeks. That's holding me up. I'm not holding you up. In fact, in the planning board's rules and regulations on filing, they have a clause that says, if you don't get things in 7 days before that are required and you want to talk about, it can be considered a de facto continuance and a constructive continuance, and they can just continue it. What I'm arguing about is my client has rights under the bylaw, under Chapter 40A, under all statutes in the Commonwealth of Massachusetts and federally, to due process, to have a set of rules to follow, and to follow those rules and be heard in a timely manner and to respect them himself. I was told I have to go to another board to talk to them before you would even accept my petition and start the clock ticking. If you don't have it in your bylaw, and you don't, because I researched it since this, and you don't have it in your rules and regulations, even if you had it in your regulations saying, we would prefer this, and you should do it, you might have something to hang your hat on, and the building inspector would. But you don't. So there's no applicability to the due process and how this handles, other than I come in, I file my appeals, you take them in if they comply with the application process. The application process, they all complied. The building inspector told me they all complied. He said, but in the bylaw it says this, and I've been told that maybe you should go to there first. So I said, okay, fine. I'll take back these 2, and I'll submit this one when I came back. And I submitted that one, and that's why we're here today. So to sit here and tell me that you have to go to the board before I know what I'm even talking about and what's before you. Because what if something changed? What if something changed in the application? Okay? So we need to have an application filed with you that's in the record so you know what you're talking about, and then I know what the planning board's talking about, and the planning board would have access to your files to take all the photos, take all the the schematics, take all the drawings, take all the other information that I have, and would also hear from the people that I would bring to those hearings to give testimony on site visibility, on the hardships and all of that. So I honestly feel he's wrong. I feel that if we're gonna have this as a policy, anybody can make up any rules they want. And that isn't the way that this town runs. I mean, what happened Tuesday night is exactly what Monday night is at the planning board, is exactly what we don't want to happen. We don't want petitioners' due process violated because other boards are having hearings and there's discussion going on out in the community that's misinformation. I was listening to it for 5 minutes and they didn't even know what was before you guys tonight. They thought, at first they thought it was the application for the variance and the special permit. My client's rights have been totally tainted here. And I want to just start the process, and I want to do it right, and I want the building inspector's decision and determination overturned, because that's the correct thing to do, and it's the legal thing to do, because you have no policy in place that says I have to do that before you take the application in.
Jeff, do you want to start?
Why not?
Mr. Morris, how we're going to handle this is, we're going to... Okay, well, just,
Hey, hold on, sir. Hold on.
what we're going to have is, Mr. Pizzoni's going to make a presentation. We're first going to have questions from the board, and then I said earlier, we will then have comment from the public, and I'm happy to recognize you first if you want to be heard. So, Mr. Walker.
All right, so I felt like we had two lawyers talking to each other, and a lot of legal jargon was going on, and some of that I understand, some of that I got to admit I'm not so sure I was following exactly
Sure.
what is being asked here. So you want to sign?
We need variances and we need a special permit.
All right, so so if you need a variance, you need to come to us.
Correct.
When you apply for it.
We've applied for it, we bring our application, our petition, and we file it with your board.
Okay. You filed something with or you put something before the planning board? No.
We had nothing before the planning board.
So the building inspector, what did you give to the building inspector?
I showed up with an application for a variance and a special permit, and he said, you have to go to the planning board before I can accept this in. And I
The
said,
variance or the special permit?
both of them, both of them. He said, I can't accept those petitions because you have to go to the planning board before they can act, the zoning board can act on it.
So-
And I said, that's right, act on it. I said, not accept my petition.
So what are you saying is, I'd like the opportunity to go before the ZBA to make sure I understand what they're gonna allow me to do before I go for the special permit, or are you?
No.
All right.
The process is, you file your applications.
Yeah.
The clock starts to tick.
Sure.
During that period of time, I have to go see the planning board and explain to them what I want to do so that they can give you a report,
Sure.
okay? Frankly, it really doesn't have to be before the first meeting, but I would tend to want to have it done before the first meeting.
Sure.
So that we could get there and you guys would have their response based on our presentation, not based on a bunch of neighbors in the audience talking to them. And I just want to clarify for Mr. Morris, most of the comments that were inaccurate were really from the floor and not from the planning board members. But that
Okay,
being
fair
said,
enough. So what are we voting? What are you asking for?
I'm asking you to overturn the building inspector, take in my application, so I have a valid application filed, so I can then take that and go to the planning board and say, hey, this is what I have before them. These are the plans, this is the information I'm gonna present, this is why we think you should agree with this, okay? And why a digital billboard is better than these other billboards that are up in the town, or the light is better. You know, I give them the reasoning to support this four-numbered criteria that Mr. Morris put in his letter.
Again, I missed the planning board meeting, and maybe I should have seen that, and that would help me. They voted 5-0 against something.
I don't know what they voted against, because there was nobody there presenting to them.
That's the problem.
No, that's not the problem. The problem is, the building inspector should have taken my permits, my applications, all in, all of them when I came in and put them in. and then the clock would have started.
All right, I think I understand that better. Thank you.
Okay. Do you have any other questions?
I'm good.
All right.
That was gonna be my questions. I did not follow why we were here and what was being asked of us,
Yeah,
so.
it's important.
Agreed.
Time of filing is very important. Time of when you have to start the hearing is very important. It's all regulated by statute, okay? The time you have to make a decision, remember you have all these requests for extensions or continuances. We have to extend also the time for you to, formulate your response and your decision.
Craig?
I guess I'm wondering if the fact that we have this letter from the planning board kind of makes this a moot discussion.
No.
I mean, we now have a letter that states this is the written report required under this section, which then I guess would relieve you and allow you to go and file the applications with the building inspector.
No, you see, because my client is entitled to his due process to go and make a presentation to the planning board.
I understand. It doesn't mean that you still won't,
Oh,
but
no,
this is now their written report.
Yeah, it is, well, it's their written report. I don't know what it's based on, though. It's
It's-
based on neighbors speaking up at a planning board meeting, I guess.
Or the letter from
The building
Mr.
inspector.
Robideau with the plans that are attached.
But what you don't understand is there are plans, there are schematics, what the sign looks like, what the LED
I understand
is
you
gonna
get
be.
the opportunity to make a full presentation
Right.
and talked about all the benefits, and I don't think you're going to lose that opportunity. But you're asking for us to reverse the building inspector's decision to not allow you to file the application.
Correct.
The only reason he's saying you can't file the application is because there isn't a written report from the planning board.
Yeah, but
Essentially,
I don't want to
right?
accept that as their written recommendation.
Are you trying to say that this should be, like,
That shouldn't even
removed
be
from the
part of the
record?
discussion.
Just to clarify, I think what he's asking for is, Mr. Brazzoni or someone from his office shows up. He has
Yes.
three things. Well, first, he gets a letter from the building inspector saying, let me back up a little bit. You first, your client.
First, I came to him and said, I'm going to file these, and he said,
Yeah.
no, I'll send you a letter,
I-
because you need the variance, you need the special permit, and you need to do this. And I said, I don't need to do that. And he said, well, it's the way we do things. I said, not according to your rules.
I get that. Go ahead. So that's first.
I'm just trying to help guide
Right,
the
so
discussion. He's
so
asking.
then I show up, or not, somebody from my office, actually it was Dominic. Dominic dropped him off, shows up with the three of them. And they say, we can't take these two, but we'll take the application to overturn me so that
Right.
I can take them later.
I understand.
Right.
And so the question in front of us is whether or not we say, no, you are allowed to go ahead and
Right.
file these, even without the letter from the planning board.
Correct.
And what I'm saying is we now have a letter from the planning board, which gives you the right to go ahead and tomorrow morning file these.
But-
When does the clock start ticking?
Yeah.
When he starts filing.
When he
No.
from before.
The clock should start ticking from, I'll tell you on the record, I will extend the time that you have to have the
Well,
permit.
that would be my concern.
Yeah,
Right.
I mean, I don't have a problem with that. I just want the timing of the application getting into you being the start.
Craig? Craig, are you?
I mean,
That's the difference. You're right. He can file, but he wants the time.
so my question to you, though, is if this letter is here and you can go and file tomorrow and that is the official start date of your application,
No, I want my applications to revert back to the date that this one, the appeal was filed.
and then we might ask you to extend it
I will
so that the
put it on the
effective-
record.
so
I
that
will,
the effective date of it is tomorrow.
well, no, I will put it on the record that I will extend the time to
Point,
have
but
Yeah.
the
due
hearing.
process.
Yes.
And I will extend the time from which for you to act.
Okay, I understand my point.
David?
So really, the whole thing that is in play here is they didn't take, like it says, to act on the special permit or variance application. So you're interpreting it as, we can't do anything on the application that you're assuming has been accepted, and hasn't been allowed to be
Right,
accepted.
you can accept the application, you can have hearings,
Yeah.
but you don't have to act on it if I don't get something from the planning board, or if they don't get it to you.
Right, so your interpretation is that should have been accepted.
Should have been accepted.
You need a variance.
Record.
You gotta go to the ZBA. ZBA, by the
Right.
bylaw, says we can't do anything to the planning board.
Right, and then I
as a written
take
report.
my filed application that has all the schematics and everything with it.
Right.
And now we know what we're all talking about, so that you don't have meetings like what occurred on Tuesday night without a representative of the applicant and petitioner there to tell them what they're doing, having meetings and hearings on it.
So-
Everybody would have the same package at that point, and they'd have access to your files because they're public records.
So, maybe you don't want to say this on record, but really what you're after is you wanted the clock to start ticking when you showed up with the application.
I sure did.
And I know that that means we need to see it within a certain period of time, but you would extend it.
I
so
would
that we're not
extend
gonna
the
put
time
ourselves
for us,
in-
for the publication to start the hearings. You know, I'd bump them the same amount of time that I've been delayed, but I want my start date to be back when, whatever the date was here, August 23rd.
So there's no net gain or loss, it's just you're on the record as saying, that was not the right process.
First of all, I'm here for two reasons. I'm here on behalf of my client because I think he was wrong. The second reason is I'm before this board a lot, and I want to make sure that this doesn't occur again, and everybody knows what the rules are.
So, you talked about extending the hearing deadline. That's for me a huge issue because, I looked at what the time frames are. So if we were to, you have a cover letter to the building department saying, here's 3 checks for $300 each. You're clearly trying to file 3 separate things.
Yep.
Appeal, special permit application, and use variance.
Right.
Okay? And he didn't accept it, and he said, I won't even accept it because you first need to
Right.
get, and the
He
issue is what's, acting upon is that.
He accepted the one, which was the appeal of his
So-
decision.
So, and that letter was on August 22nd, so if
Yep,
you add
and
this,
you took the application for this petition that you're hearing tonight in, it's dated August 23rd. It's stamped.
okay, so the huge issue is that if it's deemed filed on the 22nd, then by law, the hearing on the special permit application has to begin by October 26th, and Karen does not have the time to. So I would, will you agree to
Absolutely.
extend the deadline to begin the hearing on the special permit, as well as the variance by an additional 30 days?
Absolutely, because
Okay.
I need to publish, I need to send certifieds as well. Everybody needs the time, so I don't have any problem with that, and the client does. We just want to make sure that it's done all properly.
Okay,
But
and let me just
go
finish
ahead.
this one point. So I think Karen has you have with you the deadline extension form, so I'd like to just get that in writing and clear it out
I
and
would,
file with the town
let's
clerk.
use the dates, we can put it right on the record.
Okay, great.
And you guys, and if you want to overturn them and plug in those dates
Yep.
as extending it, I'm happy with that.
So, go ahead.
Well, the one question, so you actually had 2 things, though. When, not only do you want it date stamped correctly when you
What- can I-
bring
let me look
something
at that
in,
first.
but one of your purposes, too, is to make sure all the boards have the same information, so if it was
Correct.
all accepted, everybody gets it. So it's
Correct.
more, because what we're voting on tonight is not necessarily just his situation here. There's a bit of a protocol issue that we got
See,
to
And
all kind of agree.
And I'll agree to it. Yeah, I mean, we will bring you in those other 2 petitions with the checks tomorrow, or by Monday, let's say, at the latest.
Sure.
Okay? And that we will extend the dates for you to act based on what you're going to tell me the timelines are now.
So, but Jeff, the point you were making, I feel kind of conflicted about this. I feel, you've got an argument that the bylaw does not say that the building inspector can't reject it because
Right.
you haven't. But, I've only been on the board for 2 years as an alternate and a full member. Every single sign application I remember comes in our packet before we even begin the hearing. There's a recommendation from the planning board, yes or no. I also looked at the bylaw. It says that if they give you a negative report, you can try to modify it to, it really does seem like for kind of a,
A logical.
yeah, you should
approach.
go to the planning board first.
Well,
And
I-
you can't avoid going.
But I
to
think
the
what he's
planning
also
board
saying,
before we-
Andrew, is if he then comes before us in a meeting and he doesn't have the approval, we're just gonna continue it because we don't have the
Or,
information.
or you guys, if
Well-
you decide, you can deny
Reject
it.
Deny
Yeah,
it.
I mean, and I'm not suggesting in any way how my opinions about, you know, whether you meet the special permit criteria or whether you meet the.
Yeah. We're not talking about
there's
the
gonna
merits
be
of the
big
claim.
questions about that.
Right.
Okay,
We're
this
not
is just
talking
a
about the merits of the
procedural
claim tonight.
issue. All right, so,
It's more of a policy, and quite honestly, as a person that's done some development in different towns, it's horribly confusing. It's horribly confusing how you go through this process and get things done.
Well-
It creates more jobs for you, the lawyers, it's great, I guess, but
if-
it is horribly
Well,
confusing, and I would, as a member,
just so,
go ahead.
I think what Mark was trying to do when he sent the letter to the applicant is exactly that, to make it easier, okay? It's very frustrating for, you know, there's a commercial part here, but if it's just a smaller business, a resident that wanted to put up a sign, and they show up, and then the first thing we tell them is, well, we can't make a decision tonight because you need a written report from the planning board. They look at us, they feel like we're frustrating them. So that's why there has been this practice about telling people, go to the planning board first.
And I'm well aware of the practice and the process. Just, sometimes there are circumstances that you do things a little differently. And I'm just doing them the way the bylaw and the statutes say that we can do them, and the way they should be, because of necessity on
Trying
my
to
part.
expedite the process is
Well, it would have expedited the
Would've.
process, but it's kind of slowed it down now a bit.
So if you knew that the bylaw required us to have this report from the planning board
Yeah.
before we were to act,
Yeah.
why wouldn't you just go to the planning board? I know, I mean,
Timing,
this, you
I
say,
knew,
you know,
I look
this
at
situation was
schedules, I look
specific
at,
and, you know,
yeah, I
certain
look at,
things that you're trying to accomplish, maybe this was the more expeditious way for you guys to get what you want.
there's,
But if you know that's the
there's a
the
lot of, there's a lot of,
linchpin,
there's a lot
why
of
not?
reasons. There's a lot of reasons, and a lot of time, a lot of it has to do with timing sometimes. I mean, I'm not just before this board. I was down the Cape Monday night, you know, I was in New Jersey last week. You know, so I go all over the place, so I'm not around, and I'll look to see when schedules are and say, oh, God, I gotta get this in now because of this, or I have to do this because of that. I mean, there are other circumstances, too, that drove me to want to get this in that day.
I gotta admit, at the end of the day, the people coming before the board are our clients. We're here to take care of them and help them. He's the land, we're here to support them,
Yeah,
they're not here to support us.
Right, I'd be
Well,
be
do we-
careful.
Look, can I
Yeah,
finish
well,
my
we-
statement?
whoa,
No,
whoa,
no, stop. Let me finish my statement. This is a general opinion, definitely. If these processes take forever sometimes, because you gotta go board to board to board to board, makes no sense to me. If there is a way that you can file, know that I gotta get to the planning board before I get to the ZBA, he can still do that, but know that he's got his slot set on the ZBA. I imagine that's what you're trying to do
Right.
here. Great. Now he can
Infill.
move faster, which is, quite honestly, a positive. Great, let's move faster.
Jeff, the point was just that the applicants are not our
Right.
clients, so we're not there to serve them, we're to serve the whole
Represent
town.
No, true.
Okay,
Right.
that's all.
And I understand what you're saying as well, but I think he's really about, the process is there, but it was just the application needed to be accepted.
Correct.
Right.
And then he goes to the planning board.
Right.
That's really the
That's-
crux of it, is
Right.
that the application wasn't accepted.
And I think what he's saying is if he can work some of these timeframes in parallel
Right, this is what we're gonna do.
versus having to go in series,
Right.
Yep.
it's gonna help the situation.
Right. And you want to make sure you have a complete package, and it's the package that's before you guys, that
Right,
I'm
Andy.
presenting to everybody else.
Right, right. It's just, I'm trying to,
I understand.
boil it down to the very simple pieces. It was okay if he
I'm just
took
gonna
it and
send it
said
out
you
to
have to go to the planning board
so that we
because
can get it.
ZBA can't act on it until we get a written
Right.
report from the planning board. That's the way I understand it. Okay.
Thank you.
Okay, so I've taken the form, you know, the first part of the form is the name of the applicant, things like that. I wrote, I, the above applicant or duly authorized representative of the applicant hereby request and agree to the continuation of the deadline to begin the special permit hearing related to this matter.
You can put both of them.
Yeah, yeah. To no later than November 30th. And then what I would suggest is, our standard is we meet on the third Wednesday of the month.
Yeah.
We got thrown off last month, I had an unresolvable conflict. So, we can put this,
When do you think
first
we,
have to file, and then
Yeah.
it would be my intent to put it on the third Wednesday of November. The thing is, though, it's going to help us greatly if you go submit things to the planning board. I mean, they're going to
yeah.
have to weigh in on this.
no, I understand that. And that's, actually, that's more time than I thought. You guys are going to have a meeting the third Wednesday, which is
I was
the
gonna
Wednesday
bring that
before
up, yeah.
Thanksgiving?
It's
Could be
not
a problem.
Thanksgiving. Oh, it is?
Yeah, the
Wait,
23rd.
no, that's the
Oh,
second.
wait.
1, 2, 3. It's the 16th.
16th would be the third
16th.
Wednesday.
The 16th.
Okay. All right, yeah, I mean, I don't think, we wouldn't make the one in October, correct?
No, because it's the 19th.
Oh, okay, all right, yeah, so we've got no choice, yeah, that's fine.
You want to take a look at this?
Yeah, do you want me to extend the dates, would you have to act to?
Well, first, I don't think we've heard from members of the public yet, but we're starting to. Just take that.
Take a look
And
at it.
any other questions of the applicant?
Nope,
Okay.
nothing.
Mr. Morris, would you like to be heard?
Good evening. Don Morris, Planning Board. First of all, I'd like to thank council for stating that he didn't know what was discussed in our telephone conversations.
Oh, no, I did.
Thank you for putting that on the record,
Yeah, no, I did.
because you don't know what we said.
That's correct, and that's.
The
I just-
second thing, I'm speaking. The second thing is, anyone, you or anyone else, that comes before a public board or speaks in public and says that the planning board denies someone their due process, you're going to hear from me and you're going to get pushback from the planning board. Nothing could be further from the truth. Now, you asked, how did we get the materials? Let me speak.
Yeah, I am.
This is the agenda, public document that was posted for this meeting. Attached to it was a 2-page plan showing the site and the details of the sign. You can tell by tonight's discussion that there's quite a bit of confusion relating to this. When we received this, it's a public document. When we saw that it was on for tonight, Wednesday, we felt compelled to address this in order to keep the process moving. You can hear that there was concern about the clock running, and we felt that it was important for the planning board to look at the materials that were available and render a decision. The whole time wondering why the proponent never came before the planning board or had any submittal. I agree with what was said. Nothing was submitted to the planning board by the proponent. But the public documents can't be ignored. We have an agenda item here that talks about what's going to happen, and it also is attached to a plan. We felt, the planning board felt, that it was imperative that we provide you with that report and our opinion. We also felt that at any time, the board can reject the plan, the report relative to the sign, can reject that at any time. But we felt that it was important to submit that in the interest of making sure that you could make an informed decision, if you had to, tonight. The second letter rendering our opinion, you can throw that out the window too. We understand if you want to keep those letters, that's fine. If the proponent wants to come before the planning board and make a presentation, we will welcome that. And I would even propose to the board that we withdraw the letter and start from the beginning. It must be understood that it wasn't until a few minutes ago that we heard this discussion about time and willingness to extend. it wasn't until this afternoon that I heard through the town planner that, that the document that stated that checks in the amount of so many hundreds of dollars was actually never accepted. So we were under the impression, I certainly was, that a clock was ticking. And so the actions of the planning board on Monday night was in order to help the ZBA perform within the time frame and make an informed decision. We understand that the code requires that you get a report, and we felt compelled to do that.
Thank you.
Mr. Morris, could I see that agenda, just out of curiosity?
Again,
It's just a rebuttal, and I appreciate everything that Mr. Morris said. I truly do, but the notice that went out, and even the agenda item says, the hearing tonight is about the building commissioner's determination that the applicant must first obtain a report from the planning board before it will accept the applicant's applications for a special permit and variance to erect a billboard. So it was about just what we're here talking about.
Okay, but
and
why
the-
is it all that relevant?
No,
I don't
no,
wanna
just
get too
because,
sidetracked.
again, I just want to say, my client, there was a discussion, half an hour, I watched it. I sat in my office this afternoon and I watched it, of the planning board meeting, a discussion with a lot of misinformation coming in, not so much from the board, but from the public, which affects my client's due process. And that's part of what I'm trying to preserve here. And I appreciate everything Mr. Morris just said. I agree with him. If they didn't realize that this is all was going to be talked about tonight, that's fine. But I think it's plain as day what was going to be talked about in the notice and even on the agenda.
well, Mr. Morris, can I ask you a question? Because what you said all makes sense, but what's before us tonight is whether or not the building inspector should be allowed to accept all that information. Do you have an opinion on that?
I probably do, but going back to what you were saying 20 minutes ago and what I heard the rest of the board in the form of your questions and your statements was it wasn't clear.
It's not, no.
It wasn't clear. And going back to what council just said,
And
it was,
I think, and just so I'm clear, I think the planning board acted completely appropriately and nothing against the planning board, but I think what's in front of it, you're almost speaking as a resident, I think, at this point. Before us right now is simply, should have the building inspector accepted all the information at that one time, and is that acceptable? That's all we're talking about here, not whether or not the planning board did the right thing or the wrong thing. That's, I think you did the right thing, but that's irrelevant.
And we're definitely not talking about whether or not these
Redone.
signs
Yeah.
and variances and permits they're not even on the table.
agree.
So the question that Jeff
Yeah,
has
that's
you
what I'm
is
saying. You're speaking
the
before us
process
on this
going
decision.
forward.
You are part of the planning board. Do you have an opinion on what he's suggesting, the process, and allowing the building commissioner to accept all the applications at once?
I think that because we learned this afternoon, after we discussed and prepared that letter, when we prepared the letter, we were under the impression that the building inspector had accepted the application and the money, and the clock was ticking. It wasn't until this afternoon, again, that I was informed by the town planner that that didn't happen. So the letter, so I guess we're in agreement that, that the letter was based on a presumption and a vacuum of information relative to whether or not the building inspector had actually accepted and started the clock ticking.
We've got another matter that we had scheduled on for 7:30. I thought this might go past 7:30, but I just want to kind of wrap this up and move it towards is there anyone else from the public that would like to speak?
Let them speak first, because I just want to address this.
Yeah.
Mimi Latrell, Planning Board. My question is, what is to stop an applicant from, if an applicant files a permit with the building inspector, and doesn't come before the planning board, does not get a report from planning board,
We reject it.
you can't, that's acting on it. That a denial is
That's the-
acting on it
Continuing
Continue
it.
it.
to forever and ever.
Does it-
Until we get the report
We
from the
don't have
planning
some-
board
we don't
per
have the information.
17411.
But you need the permission of the applicant to continue it.
Okay, but just one
So
thing to think about is that,
Will the
I'm sorry.
time just toll and it be constructively approved? That's
I don't
that's
know.
my concern.
But the one thing to think about is if we get this wrong and then he appeals it and there's some determination, no, that should have been filed on August
24th.
blank, and you, ZBA, you didn't even hold a hearing, therefore the whole thing is constructively granted, et cetera, et cetera. Obviously, once this, if this is put on the agenda for November and he doesn't have a favorable report from the planning board, the bylaw says that we can't approve it. So the issue is, does act on mean vote on, deliberate, or does it mean accept the filing? I mean, I think that, you know, it makes sense to just get to the merits of this, set it up on a process so that there's a time where we're gonna decide the big issue. He has to go to your board first, and then we'll make a decision. And then he will be afforded, I think, the rights he has to,
Ye-
you know, have his client have representation at a hearing where you're gonna be discussing his rights.
I think
So-
part of the confusion has been that some people thought it was a building permit that I was appealing, and it wasn't a building permit I was appealing. I knew he had the right to deny the building permit because I knew we needed variances and special permits. And it's really that our process here in town, even our own bylaws and Chapter 40A, say this is how you do things. And we did it the way we were supposed to do it. There's nothing in there that says you have to go see all these other boards before you come to see us,
Well, I mean,
unfortunately.
this is maybe for another day, but one thing we might consider to clear this up is so that the bylaw makes clear that, you know, the bylaw could say something like the building department shall not accept any application for a blah, blah, blah until you first have filed with the planning board, but it
That's-
doesn't say that.
That's one way to clear it up. And Andrew, I mean, Mr. Chairman, I didn't have my black hat on, so I didn't think about constructive approval and just appeal you guys. I should have let you disapprove it.
So I'm under agreement there's a process problem here. So if, moving forward, so you're setting a precedent here, if you accept this appeal, that the building inspector has to accept applications on the time that they're brought to him. So if an applicant does not come before the planning board, will the zoning board contact the planning board so
That's
the
what I
time's
kind of-
not tolling?
That's what I kind of came under some fire for, was I saw an item on I was very confused about this. I saw an item on the planning board's agenda about this, so I called Mr. Morris to find out what was going on. If this whole thing can be, that's why we really want
Right.
applicants to go to the planning board first, to tell the planning board what they're doing so that we don't have this situation.
But if I'm correct, when my application would have been filed, I would have given you 10 copies, and one copy, I think, finds its way to the planning department, correct?
Of your application?
Yeah, my application, all the filings.
The planning board asked us for a copy of the
No,
application.
no, but under the normal process, when I give you 10 copies, they don't all just sit in your office. They go to all the different departments, correct? Public safety, fire, public works.
If it
Yeah.
is necessary for,
Right.
that application, yeah.
So they would have had notice, and frankly, like I said, I would have scheduled it because I was going to be around, although I wouldn't have been around Monday night. I would have had to schedule it before Monday night with the planning board. But no, the process is flawed, so it should be a little bit more in tune.
Agreed.
Are there any other members of the public that'd like to speak on this, keeping in mind that we're now running 25 minutes over?
Okay, if I could, Andrew, Mr. Chairman, I think this is all we do have to put, because the other dates run by the number of days from the application,
The
correct?
variance runs from the day the variance law is we got to make a decision within 100 days of when
Okay,
it was
so
filed.
I'm going to put and extend the decisions 30 days.
Okay,
Okay?
thank you. All right, do we have, I think we're done with our Discussion on this?
Open discussion.
Move to close
Yeah,
discussion?
Do we have a motion to close the public hearing?
I move to close the public hearing.
Second.
All those in favor?
Aye.
Did you get that? Okay, so now on the merits of this, do we have a motion to reverse the building inspector's decision and accept the filing as of the date that Mr. Pizzoni presented, I think was August 22nd,
23rd?
the 23rd.
We can have we're allowed to continue open discussion here, right?
We're now in deliberative session.
Deliberative
August
session.
23rd.
Yeah. Keeping in mind, sorry to interrupt you for one moment. The key point of this is we should take a motion to accept this extension of time.
Oh,
It's part of it, yeah.
Yeah.
That be as a-
Do you want me to
Yeah,
make it,
absolutely.
Condition, or?
do you want to make it, yeah, you can make it a condition. I don't care, because I'm giving it to you
I mean, it's
anyhow.
there being done.
11:30, you don't want to make it 12:30.
Let's do 12:30.
Okay.
But
here's sort of the three things. One, absolutely go for the extensions that he's requesting. Two, I definitely think there was confusion in the bylaws and that they were following the rules. But three, we're setting, I don't want to necessarily set the new rule right now, because we're making a quick decision that could have unintended consequences that we don't understand. So I don't necessarily want to rewrite the bylaw as we sit here to make sure that maybe we're talking to outside counsel or what have you on, making sure none of the unintended consequences don't jump into it. But again, go back to my second point, I think they had the right to do what he did, and it should have been accepted based on the way it's written now.
okay, so
I don't know if that's a motion, but
Well, I mean, I think for clarity, as far as the zoning bylaw, we don't have the right to do
Right.
that.
No,
That's
I
town
agree.
meeting, right? So
Right.
that has to be, that would have to go before town meeting to be clarified. I would agree that there's certainly a little bit of confusion, and I think I basically agree with what you're saying, Jeff. As far as, I think I'm like Andrew, I thought it was really black and white before the meeting, now I have a better understanding of it. It's really about, the process is to accept it and then continue.
If I could, and I don't want to shoot myself in the foot here.
it's closed to the
No.
public.
well, yeah.
No, it was just, I think you can, your
No,
rules and
we can't.
regulations can be
Can't.
altered by you guys.
But not tonight.
We're in deliberative session.
Okay, so is there a motion to reverse the building inspector's determination and accept the special permit and variance applications as of the time that Mr. Pizzoni attempted to file them, and also accept his gracious extension of the deadlines to decide this? I know that's a mouthful, but does someone want to attempt that? Maybe break it into parts? Maybe we should do two
Yeah, let's do
motions.
two motions. I would motion to accept the extension of the applicant.
Well, I think you need to accept the first part first.
Right.
No.
So, do you want to make them?
I just want to, again, make sure that I'm not, as the second planning board member who got up, I forget your name, I'm sorry, stated, we just got to be careful. We don't want to set precedents and what have you. So,
Yeah.
but I would make a motion that the zoning bylaws were not clear enough, and that the building inspector should have accepted the.
Just a motion to reverse the building inspector's
Yeah,
determination.
How about that?
let's not get
Because
into the
the clarity
bylaws,
is
let's just
not-
make
I
it
don't
simple.
think,
All right,
of-
there you go. You can make it.
Just, I make a motion then to reverse the building inspector's decision and accept the application that was filed as of the date of August 23rd, 2016.
Is there a second?
Second.
All those in favor?
Aye.
Okay, and now,
I'd like to make a second motion that we,
Did you
Oh.
vote? He brought the motion.
I'd like to make a second motion that we accept a extension for the time in which
Yeah.
to perform.
All those in favor?
Per the, I guess, per the,
Yeah, and
form.
I've got the signed, the deadlines to begin the public hearings on the special permit and the variance are extended to no later than November 30th, 2016, and the deadline to make a decision is December 30th, 2016.
So are you saying that as the motion?
Sure.
I'll second that then.
I think we've already voted on this. I'm just clarifying.
You're clarifying it, okay.
Okay.
Actually, we didn't vote on that.
We didn't vote on this?
No.
Okay, let's
All those in favor?
take another crack at it. Dave, do you want to?
That's why I was seconding it.
Okay. All right, I make a motion that we accept the extensions suggested by the applicant to have the variance hearing.
To begin the hearing.
Begin the hearing no later than November 30th, and to make a decision no later than December 30th, 2016.
Is there a second?
I will second that.
All those in favor?
Thank you.
Okay, I think that concludes this.
Karen, what was that date in November, 11/16?
November
No, no,
30th?
no.
16th
Oh,
is the
I-
third Wednesday.
Yeah,
Third Wednesday.
I have to put it in my
That's-
calendar.
The 16th? Yeah, 16th
16th.
or the 19th?
16th is the, because the second.
Okay, thank you.
Okay, the next matter on the agenda is a variance application from Robert Morrison. And I think Mr. Bartolini is back on. Thank you, David.
I'm David. Is there anything else after this?
Yeah, we've got some other important things, too.
Yep.
Okay, is Mr. Morrison here or a representative? Can you please come forward to the desk?
I do have a couple more of these.
Yep. Thanks. And then Karen,
Actually, let me switch.
will you read the public hearing notice?
Andrew,
Yes?
can I switch with him on this one? I just got a little family crisis I want to deal with.
Okay, that's fine. David? Yes. Are you,
I should point out that I am in a butter of 15 Meadow Lane.
okay. So that's an issue. Jeff, I mean, it's up to you. I mean, we
Well,
can,
if you got a
Yeah.
quorum, I can,
we will have a quorum with
All right.
4.
I got to deal with it. Thank you.
The thing, Andrew, the thing is that he needs. to
Mr. Robert Morrison, 15 Meadow Lane, Southborough, Mass. The Board of
Oh,
Appeals
okay.
of the Town of Southborough will hold a public hearing in the Thomas J. McAuliffe Hearing Room of the Southborough Townhouse, 17 Common Street, on Wednesday, September 28th, 2016, at 7:30, with regard to the petition of Mr. Robert Morrison, 15 Meadow Lane, Southborough, Mass. The petitioner is seeking a variance to construct an attached two-car garage with future living space above the garage. Relief is requested pursuant to Section 174, 8.3 D.C., side setbacks 15 feet. A copy of the application may be reviewed at the office of the building department at the townhouse during normal business hours. Andrew R. Dennington, Chairman.
So the way this works is you have an opportunity to make a presentation here. You're seeking a variance. Really, the key issue here, and you should address your presentation too, is review what you're looking to build, and the standard is whether you have a hardship where if we were to literally enforce the bylaw, it would present a hardship for you, so.
All right, good evening. Thank you for hearing my case. I'd first like to point out that we're residents, we're not land developers. We've lived in Southborough.
Is your mic on?
Oh, I don't know. Can you hear me better now?
Yeah, thank you.
We are residents, we're not land developers. We're not trying to flip a house or anything like that. We've lived in Southborough for about 12 years, 3 years at this house, and then we lived previously on Parkerville Road. My son Jake, who unfortunately had to come with me tonight, is in the Southborough school system. We like to, keep him there. So this is, just just trying to, you know, show the basis that we live in here. We're just trying to improve this for our own value.
Okay, I know you're maybe a little nervous. Try
I'm
to just
very
speak
nervous.
slower.
Okay, we're looking to enhance our property for livability. Being a typical family with 2 cars, their existing single-car garage is too limiting. Our hardship is the shape and topography of our lot. Our lot is long, but it's narrow, as you can probably see from the plot plan. In comparison to other lots in the neighborhood, which are more square and provide more sideways room to build, our lot is narrow going back a ways. So adding the 2-car garage onto our home, the most logical place and the most effective place to place it would be on the side of the house where the existing driveway is. And unfortunately, that presents the reason for this case, because that pushes us to encroach the side setbacks. Again, other properties in our neighborhood have wider lots, and we're not running into this issue. They would be able to build such a structure without running into the variance. I have spoken verbally to the direct abutter who would be most affected by this. Unfortunately, I couldn't get an email from him. You didn't receive any emails today, I take it? Yeah, unfortunately, he wasn't able to send an email, so I don't know if you can accept that as anything, but he did inform me that he has no objection whatsoever to us.
Is that
doing this.
Howdell?
No, that would be
You're,
Roger Poole.
okay.
The abutter on 11 Meadow Lane is the one that's most directly affected by the structure.
Did you talk to Richard Howdell? This is the record owner. I don't know if that's who lives there, but.
I have not spoken to him directly, no.
Actually, I drove by there. It looks like that house is for sale.
I did, the one on 11 Meadow Lane is for sale. Richard Howdell is on 9 Meadow Lane, and he's not like immediately on that part, he's on that edge of my property, but on the back half, not up on the driveway where the structure would be
All the
built.
abutters have been given a notice of a, what do you call it?
I mailed out
Karen
19
has.
notices to all the abutters on the list. I've received back 18 of the green cards, so only 1 did not acknowledge the receipt of it.
Thank you.
I think that's all.
Okay. Paul?
Are we done with the presentation of this?
Oh, I'm sorry, I did want to point out, I don't know if you can see, the pictures didn't come out as clear as I would like, but you can kind of see that on the driveway where the structure is to be built, there's already a fence and several trees and bushes on that side masking our property from the neighbor's property.
Yeah.
So the visible
Thank you.
effect is, you know, not quite as dramatic as it might be if there was no foliage.
Paul?
So, I mean, I follow what you're requesting and understand the fact that you'd like to have a garage added to your dwelling.
Yes.
Then it makes the most sense to have it where the driveway currently is. You know, it does encroach by quite a bit into the setback. So we've seen other, you know, proposals where it's, you know, sort of encroaching a little bit, maybe questionable. And this seems to be quite a bit. Following the logic that you wanted to do this and keep it where the driveway is, I mean, I see a plan here. I mean, it doesn't show topography, it doesn't show, where septic is. Was there any thought of moving it directly behind the house, where then you could situate it where it wouldn't go into any of the, encroach upon any of the setback requirements?
To add on a 2-car garage behind the house, it would end up running over our septic system, yes.
Okay,
if
that's
we-
what I'm
if
saying,
we-
because it's
yeah.
not delineated on here.
Yeah,
as
they
to
didn't,
what-
I'm not sure why he didn't show that on there.
That's the only reason I asked, so that would be that would be within the setback from your septic system then?
Yes.
So okay.
I mean, there are other reasons why it's not desirable to build behind the house like that. I'm not sure how effective they are in demonstrating a hardship, but I can explain further if you like.
Well, sure.
Well, one of the big detractors to building an attached garage behind the building was that it completely changed the roof line of that back half of the roof. which many contractors said was much more, prohibitively costly, as opposed to adding the structure on the side and then connecting on the side of the existing roof. Again, I don't know how that goes towards hardship if it's only a matter of money, but to us, it's rather important.
No, but I mean, again, re-engineer it or redesign it, but I mean, it could be, septic system aside, it could be done, it could be tied in, it could, much the way as this is being tied in. I can see from this, you could have, again, it could have been done, except for the fact that it encroaches upon the septic
The
system.
septic is definitely a big factor, yes.
Paul.
That's my thought.
Okay, thanks. Craig?
How far away is your neighbor's structure from the other side of the property line?
I'm not sure exactly. I would estimate 25 to 30 feet.
Blue one's his lot.
Yeah.
I know he had a shed on the property, which would have been, the 10-foot setback, and the house is probably twice as far away as that shed was, so probably 20 to 25 feet. And he actually has a raised septic on that side of his property as well.
I know you say your septic is a limiting factor and a hardship of where you could possibly place this. With this amount of additional square footage being put on your house, is your septic system sized appropriately to handle it, and would you not need, in that situation?
There would be a bedroom consideration, not a.
It's square footage, and, these could be used as bedrooms. They're full-on rooms,
Yeah,
So
that's a.
Yeah,
if you're gonna have to redo your septic system to accommodate potentially 3 new bedrooms, or at least 2, would that not be the opportunity to put it back where the current septic system is?
Yeah, I understand. Actually, it's a brand-new septic system that we had to put in when we bought the house, because the previous one had failed. And when we put in that system, we took the opportunity to put in a 4-bedroom system to make sure that we'd have some increased capacity. We have absolutely no intention of putting any bedrooms in that upper space. Where the garage attaches on the 2nd floor is our master bedroom, so our intent is to, in the future, expand that space to be a master bathroom and walk-in closet and then additional storage space. We don't intend for living space in terms of a bedroom or a family room or anything of that nature.
And the other hardship is you have 2 cars, 2 garage spaces would be needed.
Mhm.
You already have 1 garage space. Why wouldn't a 1-car garage, which would accommodate the appropriate setback, be the right solution?
We felt that it would be a very awkward design to try and add a 1-car garage to the side, for example, and have then the 2-car garages. Putting the second bay behind, for example, which might barely fit within the setbacks of the septic system. Again, that gave us the extra expense of having to tie in a new roof system into the existing. It also didn't allow us, one of our secondary goals, which again, I'm not sure how it goes towards hardship, but one of our secondary goals was to be able to have a door to the backyard through our living space without having to walk through a garage to get there. And this accomplishes that by having that entry room that separates the garage from the main house. But mainly I would say just stylish considerations to, if you see the other houses in our neighborhood, a lot of them are much bigger than ours, and they have the garages placed just so and so on. And not that we are trying to compete with the larger houses or anything of that nature, but just try and keep the architectural style of the house and the garage to kind of conform and look nice and pleasant together was our goal.
Okay.
Lee?
The only question is, you're not considering using that for an apartment or anything, it's just strictly 2 units, bedrooms for the house?
Not even bedrooms. We plan on expanding our master bedroom into that to become a suite, a master bathroom and a walk-in closet.
Okay,
Yeah,
I
definitely
have
no
no further
apartments.
questions.
Are there any members of the public that would like to comment on this application? Seeing that there aren't any. Paul, I can barely.
You want to make a motion to close the public hearing?
I think,
Any discussion amongst
yeah,
the board?
we don't anticipate seeing any need to have, here's my concern is, sometimes when we close the public hearing, and then we have some questions, we want to talk about conditions or thing like that, then we can't talk to the applicant. So, we can just begin a discussion and we'll see where it goes. I don't know what people are thinking. So, Paul, what's,
I mean, I guess what I'm thinking is I think there would be a way to perhaps obtain if the ultimate goal here is to obtain a second car garage, and I would think there is a way to obtain one without needing a variance and without encroaching in the setback from the septic system. So I think that is obtainable. The objection to that would be, maybe aesthetics or economics, but it is doable. And my recommendation was that should be looked at and considered before a variance is granted. As I said, because this is, and I guess a variance for an encroachment is a variance for encroachment, whether it's, 6 inches or a foot or, 7 feet or 12 feet. So I guess that is irrelevant, but it's not, it's not like it's just encroaching by a foot, it's encroaching by quite a bit. So in my opinion, there is a way to accomplish having a 2-car garage that would not require a variance for a setback, and would not require, encroachment upon the septic, without the benefit of seeing where the septic is actually located. That's my thought and opinion.
correct?
I also kind of agree that there's the ability to add garage space without encroaching. Simply to have 2-car garages, you already have one. A single-car garage would not encroach. One of the concerns I have is with that house and a butter being up for sale, having a mechanism to have that as a disclosure to anyone trying to buy it, that if this were to happen, there's going to be a structure that is outside of our zoning bylaws that you're buying next to. So I'd want to see something along those lines to make sure that down the road, the people buying that house are aware of it, and quite frankly, it doesn't come back to bite you either.
Lee?
I have no comment.
Well, I don't know if we have a consensus here. And, these are difficult applications to take from the homeowner. I mean, my concern here is that some of the other variances we've given for residential structures are, some recent ones where someone puts on a deck and it's just facing towards the woods. No one is really affected by it here. I mean, just looking at the size of the house and what you're proposing to construct, it does go, pretty close to that wall. And as Craig mentioned, there's someone that's going to be buying that house who, we don't know who that is. They haven't really had an opportunity to weigh in on this. The hardship is difficult here. So what I would suggest is that we just deny the application without prejudice to your
I was
ability
going
to
to
come
say,
back.
no, I would actually recommend that he withdraws it without prejudice and explore other options, and maybe even, I guess, get notification too, and, comment back from that direct abutter perhaps. But
Yeah.
I would withdraw. And I think, is that, Lee, is that the more proper terminology here? To withdraw it without prejudice, rather than us denying it?
Well, if the issue is with purview of the abutting property, I think that he should request an extension and talk to the abutter that owns the property and see if the individual wants to come in front of us and say he does not have an issue with it. We've permitted a lot of these houses with porches and garages on the sideline due to a long lot that has short frontage but is very long and deep, and there's been a lot of them done. So if the issue with the members are the abutter, so I think the request is that he makes a request for an extension, and that you talk to the abutter, and if he comes in or writes a letter that he agrees he doesn't have an issue with it, then I think the board would probably go along with approving it.
That
I
would-
think that would be
That
the
would
proper
be,
way of doing it.
that would be that would certainly would be a helpful, feedback from that direct abutter. And I perhaps agree with you that that an extension might be, probably is the better way to handle it than a withdrawal. Just
Okay, here's the issue though. If we continue this and we put it on for the next, for the next hearing, we don't know whether this house is gonna get sold or the person's gonna come.
Well, if it's sold, then that's somebody to ask to comment.
But the thing is,
But that changes my
presently,
case.
it's the owner
Yeah,
that make a comment, and he's not selling it, so make the owner, and the thing that
whoever the
can
owner
be
of record is at the
done
time.
to protect, the thing that can be done to protect it is, and you tell the owner that in the sale of it, that there's a notification on the sales agreement, what's going to happen.
that's a condition once we
Yeah,
possibly approve it.
right.
But by asking him to extend and continuing it, we can't make that a condition.
No, at the next meeting we can.
Right, but that's,
Yeah,
But
we
it-
also
which-
have there's a 100-day deadline, so by law, we need to make a decision. We'd then be asking him for extensions and extensions.
Well, I
I
mean,
think one extension still keeps us within 100 days.
in an attempt to contact that abutter, I mean, I also think it would be a good idea to look into, just look into into a design and plan that, does not get into the setback and it does kind of tie into the existing, and perhaps that, not saying that you didn't, and I understand you say you
We reviewed
you did,
several,
and
but
it
yeah.
was aesthetics, it was economics, but,
Mhm.
that doesn't necessarily constitute a hardship. So I would recommend that, during that extension time, that, maybe that get looked into a little bit further perhaps.
Or if you did and you have some preliminary drawings that show it and explain why it doesn't work, then just share those.
So then, that's why I was thinking, if we just denied the current application without prejudice, then he can, after whoever moves, that person will be there, a new application will be filed. If he has a new plan, we get a new plan at that time, because it sounded like what you were suggesting is some totally different design to avoid the setback issues.
Well, it's, totally different, but we're not redesigning an entire home here. We're designing having the design of an addition looked at. So, I think that's, something that is doable.
The proper way of going about it would be then he requests to withdraw it. Because if he goes the other way and it gets denied, he's gotta wait so much time before he can submit it
Right,
again in
that's-
front of the board.
Okay.
That's why I don't want,
Which is
that's
the
why I don't
longest-
want to put a denial on it for you, because
Absolutely.
that would,
So just make a
Handcuff
request
you.
that he just make the request to withdraw it.
and I would, since we're still open here and talking, and, look at the other design and perhaps contact that direct abutter for, some type
Well,
of,
he can resubmit it any way he wants.
Okay.
and then
after he
resubmit.
withdraws it.
So, sure.
So,
You had a question?
yeah, I'm sorry, are we now talking about me withdrawing the application or asking for an extension?
Right now, we're just
Then
talking
talk
about
about
you withdrawing it, okay? So that's so that you don't have a denial, which could be, negatively affect you, but you don't have an approval either, right? You've got the benefit of our feedback. You can think about different ways of addressing the concerns of some of the board members, and you just come back before with a new application. You would need to then file it, you pay the fee, you notify everyone, and then the next time it comes before us, we'll be closer to making a decision on it. Does that make sense?
And the other issue would be, if you did what Paul says, and you move the garage into the rear of the building, you don't have to come back in front of us, because the building inspector will give you a permit.
Right.
So that's something you can consider, that if you get away from the side of the house and put it in the back, then you won't have to.
Is the main concern the amount of the encroachment still, or just the fact that there is an encroachment?
That there is an encroachment, and, I mean, it is very close to a neighbor's lot line that we, have no idea if they,
Just wanna make
again, they
sure.
were notified, they're not here, but I would feel more comfortable if there was, if they indeed didn't at all mind, if they, basically stated that. But I would also like to see you explore the option of going behind without having to talk to us at all.
Right.
When were you
Yeah,
looking to
very
start
tough. Okay,
construction?
I got it.
As soon as you guys
No.
approved it.
No.
I mean, we were trying to get the foundation poured before snowfall, so we were hoping to get the foundation started next month or November,
Okay,
because we know it'd be tough to, otherwise we have to wait till spring.
right.
Any other questions?
I mean, I don't know if a precedent is allowed. I do remember when I was living on 190 Parkerville Road, a neighbor across the street had asked for a variance for their garage, and I know they are very close to the border. Unfortunately, for my case, they're not next to, like, there was no abutter, they were next to a road, but I know there was a variance passed for a garage that came very close to the border.
True, and it's not necessarily apples to apples with, so.
So, Mr. Morrison, are you agreeable to withdrawing your application this time, understanding that, our minds are open? You've had the benefit of our feedback to come up with a new application.
Yes.
Okay, so I'm gonna
If it's a denial, then yes.
give you I understand this has to be in writing, so I'm just gonna give you a very simple handwritten piece of paper which says, I hereby withdraw my variance application regarding 15 Meadow Lane.
Without prejudice, you might
This
wanna,
is without prejudice.
It's not. You can withdraw
just-
for,
yeah, but just for the record, there was no.
Yeah,
there was
sure.
no prejudice involved with it.
928. Okay, why don't you take a look at this? Okay. Here. Okay, thank you very much, and thank you for coming for us. Do we have a motion to close the public hearing on this application?
move to close the public hearing.
Is there a second? Who made the motion? Craig made the motion. Paul, we need a second.
I second.
Paul seconds. All those in favor?
Aye.
Okay, the next matter we had on our agenda has to do with our regulations. I don't think we have time to really get into this in detail, so there's no urgent need to address this. I just remember the town clerk, Mr. Hegarty, came to us back in June. He noted that the only thing which has ever been filed with the town clerk are these regulations from 2007, okay? But if you look at the town zoning bylaw, there's a slightly different set of regulations. I did actually print them out. I can distribute them. It's a very technical thing. We should, I think, at some point meet. It's not a public hearing. It's just a meeting where we talk about, okay, what are our regulations, and just decide it, clean it up.
I think the thing that we do, we have some regulations that have been changed that we've done. The other thing is, due to the fact that we're going to get new members, that we probably should wait, where we're gonna go over all the regulations, and that'll give them time to entertain and learn the regulations and rules too, which is gonna be a couple of more weeks, so.
I agree.
I think that's the way it should properly be done. Because since 2007, there have been a lot of changes in regulations done by the board,
Yeah. Okay,
so.
so I don't think we
you're
need,
right. No, I agree, you're right.
yeah, I don't think we need to take a vote on this or anything. We're just gonna
Just
take
put it
the-
on another agenda.
I agree.
So, and the thing is, I think that when you put it on the next agenda, that you're going to put it on, that you put it on, so it's under a public meeting, not just discussion, and that we have, you know, a scheduled time to do it.
That's right. I mean, there's a danger that we just keep kicking this down the road. Every time we meet, there's pressing applications, but at some point, we are gonna discuss this.
Okay.
Okay, the next matter on the agenda is Woodland Meadows. Is the applicant here?
Yes.
So on this is not technically a public hearing under the Massachusetts general laws. So there is no public hearing notice to be read. Jeff is not here, so that we can have a full board. David, I'm going to appoint you to sit on this. Thank you. So, I know Mr. Bartolini sat on this matter when it was considered, and I know he's got he can explain this better than I can, but basically, so the board understands, the applicant sought a comprehensive permit, a 40B, way back when. There was a whole long process. And ultimately, he got a comprehensive permit. He's now in the process of building that, okay? And then Mark Robidoux gave him a cease and desist letter to say that a certain aspect of it was not in conformity with the plans. And now he's coming before us seeking a determination that this change, and it has to do with the bump outs of the homes, is a change. Is it a substantial change, or it's an insubstantial change?
Yeah.
And if it's a substantial change, then we go on and hold a public hearing on it. It's the same. It was the same legal issue with the Oregon Road project that we dealt with a couple months ago. So, have I described that
Pretty well.
accurately?
The only thing is that the issue we have is the buildings that is being built now, that just got put up, the plan that was submitted to the building inspector wasn't the original plan that was approved by the zoning board. The zoning board approved a plan that is what he's building, but the plan that was submitted by his engineer was an original plan prior to the approval of the other plan.
Wait, submitted to whom?
Say that again?
That plan was submitted to whom?
To the building inspector.
So-
We approved it and everything, but then when they went for the building permit, they gave him a plan. And the plan that he got was different, so there's two plans, and they should explain the reason what happened with that. That's the major issue, and that's basically why it doesn't have to become a public hearing.
So, could you please introduce yourself? I don't know.
So I'm Mark Kablak. I am the attorney for Woodland Meadows LLC. My offices are in Westboro. My condolences to Mr. Bartolini, who probably thought he would never see me again regarding this application. And with me tonight is the principal of Woodland Meadows, Bob Heavey, in essence, the builder of this project. I agree with the depiction of the procedural reason why we're here tonight. Basically, the request for an insubstantial change is a decision by this board that it doesn't warrant a hearing, but you do need to make that decision as a constituted board in a public meeting. We, in fact, have had insubstantial changes to this application on a few occasions already. The application does date back a number of years. In fact, the original application was filed in 2007. And I want to talk a little bit about the history because it potentially explains the plan discrepancy that we're here to talk about with you tonight. The application submitted in 2007 resulted in a board decision in 2010 that was appealed administratively to the Housing Appeals Committee. That resulted in a remand order to the zoning board in 2011. And in 2011, Mr. Bartolini and the other members of the board at that time approved an insubstantial change, which basically granted the comprehensive permit under which we're building currently. The project is 16 units. It's off of Oak Hill Road. 4 are already up. One of those 4 is an affordable unit. The balance of the units are along the side of the property as you go in from Oak Hill Road. when the comprehensive permit was finally approved and we were recording plans that were endorsed by the Zoning Board of Appeals, we took an amalgamation of plans over the course of that period of time that I was just going through with you. So basically over a 4-year period of time, over multiple hearings and submissions to the board, and at least one remand back from the Housing and Appeals Committee. And the applicant and the board did the best they could do at that time to constitute a set of plans that they endorsed and that I then recorded. Those plans exist at the Registry of Deeds. It's a 4-plan set, and 2 of those plans were referenced in my September 16th letter.
What's the date of the plans?
The plans are dated July 2009 and August 2009, and they were recorded in 2014. I have one, I didn't make multiple sets in terms of 7, but I have a, 1. This is the 4-sheet plan set that was recorded. 2 of those plans, and this is the issue that Mr. Bartolini was just referring to. 2 of those plans that were attached to my letter, which were sheet 2 of 4 and 3 of 4, incorrectly showed what we inarticulately are referring to as the bump out. The bump out, in effect, on these townhouse units was to afford an area for a farmer's porch and a kitchen. They were meant to be in the front of the units, not in the back. The sheets that I just referred to you, which are the same sheets that the building inspector has on file, incorrectly show those bump outs for the side units. It correctly shows the bump outs for the units that are already built on Oak Hill Road. The plan that I submitted to you tonight, is the one where if you grant an insubstantial change, we would ask you to sign, corrects that, and shows the bump out for those side units in the front. There's no change to the footprint of the unit, there's no change to the square footage, there's no change to the orientation of the townhomes, there's no change to where the affordable units are going to be placed, and the important thing that the board voted on in 2011 was that the 10-foot setback, that there be a 10-foot side yard setback, both on the southern and northern portion of the property, and that 10-foot setback will still be met.
Now, if you switch the bump outs, right, you put the decks now in the back towards the property line, I mean, is there a piling or something from the deck that's then gonna get closer? Does the deck get closer?
There are no decks on these units, they're at-grade patios in the back, and the bump out is a farmer's porch in the front.
The deck is put and built in here. In the back, all there is the secondary access door of the building, which is a double slider, and that would only be 3 feet in diameter for a walkway, is that correct? Correct. So that'll withdraw the setback to 7 feet instead of the 10, which this is something that was originally discussed back years ago when we did this. And, I mean, and the thing about it is that these decks were going to be facing the abutters property, so people would be sitting on them that way. The new decks are facing each other in the middle of the road. The north side is facing south, the south side is facing north, but in the middle of themselves. They're not facing outside of the property on the decking.
Do you agree with that?
So, yes, so in essence, I think the error was due to the lapse of time between the initial submission and the approval. The submission of plans for endorsement was, again, an amalgamation of plans over a number of years. The plans that were recorded, those 2 sheets that I mentioned were incorrect. The idea was always to create a farmer's porch. The front units do have a farmer's porch, and we want to do the farmer's porch on the side units as well. The 40B regulations allow you to make a determination of insubstantial change if you feel that the changes that are being made don't impact the issues that you were concerned about. And that's why I raised the 10-foot setback, because that was one of the things that the board, in fact, when they granted their waivers from the dimensional requirements of that zone, specified that they wanted a certain minimum setback along Oak Hill Road, 15 feet
From Oak Hill Road.
from Oak Hill Road, which the front units provide, and a 10-foot setback along the north and sidelines. And that we're maintaining. Again, no other changes to footprint.
The major issue with the sideline setbacks were, there was a major discussion that they only wanted a 4-foot setback.
The abutters?
No, the owners wanted only a
Oh,
4-foot
okay.
setback.
You want to put it right up to the line?
That's, yes, and the thing about it, there was all kinds of discussions, and there was an issue with, property in the town of Marlborough, which had done just the 4-foot things that Mr. Heavy brought in front of us. And in lieu of that, we got him to agree to go to the 10-foot buffer zone when we did it. And it was all set that way, where the other way, it was going to go in front of mass housing for only 4 feet. But we did get to do the 10-foot. The only other thing is, other than all of this, and it was requested by one of the members of the zoning board to change the porch plan on the house originally to add the extra room in the kitchen, wasn't that what happened? And it was done by one of the members of the board, which caused the issue of the porch and everything. The only other outside issue is that there's some different things that presently haven't been done yet. And I think that in the lieu of what you've got, I don't have a major issue, but I do have a major issue that the original on the site plan, landscaping, and those issues are properly done. And I don't know if Mr. Heavy remembers, but back in the original, on the Waldron side of the property, we had stated that the trees that were gonna be planted there would be planted there in the beginning of the construction of this property.
I don't recall that, but
But it is in the decision, I did look it back up. So this is something that, I think you have to consider and think about. And the only other issue is, that I saw, is you've got some stone walls along the property, in the front and in the back. And the original plan has cement walls approved. And you brought us engineered cement block plans from the company in Framingham, which you submitted, and in the back, there's supposed to be the cement walls along the south side property line,
we didn't raise the elevation as,
and the fences and stuff. So, the first building and now this other building, so that's something that I think as you go forward, you have to do.
yeah, the elevation didn't come up like we were when we were originally talking about those high cement walls. The fencing we're gonna be putting up, as you recall, we recently took a tree down that was kind of on both properties, and that was kind of holding us up to some degree, but we're pretty close to getting ready to start the fencing.
I walked the site, matter of fact, this afternoon, and behind that new building, you're about 4.5 feet lower than the abutting lot.
Exactly.
So in the front of that, where they have a shed and some different things, I think in that particular area there, that you may want to consider putting that wall in. The lower wall down by the back units, I forget how many feet, is the original stone wall that's there. And that is on our approved plan that we did. But that wall, the other wall, I don't think it has to be at the same height, because the, has changed the design of the height of the elevations and stuff. But you do have to do that, that other wall does have to go in there, I think. So that's something that you either do, or you bring it back in front of the building inspector, and it'll have to come back in front of us again to be discussed.
I don't know that unless, I'll have to check it, but I don't think that was shown in the final decision. The elevation doesn't require that wall. We're gonna do a fence there, a wooden fence that would separate the two properties. And what we're trying to do is keep the elevation lower, so that we don't affect the abutters as much. If we raise the elevation, which if we put the wall, we would, we're gonna be, the new owners are gonna be looking right down on them, whereas the way it is now, they are more or less looking down on the new owners. But if we bring it up to the same elevation, I think that's a negative for the current abutters.
Lee, I know you and I have talked a lot. I don't even remember whether I've gone through the whole line here. If any other members of the board have questions, David, do you?
No, not really. I mean, it seems, I think Lee's got something that's a little bit more in depth, and I don't have that depth of it. But I mean, as I understand it, if you drew a line across where the farmer's porch is, your footprint hasn't changed at all.
No, it hasn't.
Correct.
Correct.
The location hasn't changed at all.
No.
It's just like you've made a mirror image of them all, so.
Yeah.
I don't have any further questions.
Paul?
I do have a question. So I follow what the request is here. I agree with Dave was just saying, it does seem insignificant to me. It's the same footprint, it's just in the other direction. Question I have is, so then you're right up, as we just discussed, you're right up to the 10-foot setback.
Very close.
When it was facing the other way then, you know, like on the ones that were submitted, so then your egress out the back of the house would be onto that porch, and then, which is within the 10 feet of setback.
With the 3-foot steps off of the porch.
There was still off
Yeah.
the porch, but that goes into this jogged out area here,
No, that jog is the porch.
is the porch.
Yeah.
So,
Was
all right, to land the plane, my question is you have the 3 feet of stepping stones, whatever it may be back there, that is within the 10-foot setback, but that was something that was originally approved and okayed?
And it's not gonna, it's gonna be a deck. It's like 3.5 feet above the ground.
But
So
if,
that's the farmer's porch up front.
if I'm
He's
following
talking about
this,
the back.
so if
The
I'm
back.
following this correctly,
The back exit.
so before, that was porch there then?
Yep.
And then there was
Yep.
3 feet of walkway or steps?
The step,
So those steps always did go into the 10-foot setback?
they do, but not completely. They don't, they only infringe less than 2 feet.
The farmers, if you were to draw a line on each townhouse unit between the two bump outs, the
Yes.
bump outs are actually kitchen eating areas.
That's fine.
If you were to draw a line between the two bump outs on each townhouse,
Right.
that constitutes the farmer's porch.
Okay. So my question is,
And then the steps would go down from there.
so then there's but even on this plan, those steps would have been in the 10-foot setback?
Correct.
So they're still in the 10-foot setback, that's not changing?
No, that's not changing.
So there's nothing that is in the setback that was never in the setback before? There's nothing that encroaches upon the setback more
No.
than it did before?
Nothing.
Yeah.
That was my question.
I don't have any questions.
Okay, I mean, do we have a consensus about, it sounds like most people feel that the change that's depicted is not a substantial change. Is that correct?
Yeah, but
I-
there are some issues on this site plan that need to be taken care of.
Could I meet with you out there sometime, Lee, and you could point out?
I would agree
those
that I don't
issues?
think that's the question in front of us, though.
What?
The other issues on the site plan.
Why?
Well, because I think the question of what's a substantial change is just about the siding of the units and flipping them so the porches or the farmer's porches in front.
Right, but the thing is, the abutters of the property are here, and I think we should give them the right to make a comment that they have on this area. And I do understand that the way these houses are and the way they're built, there are no legal property lines showing what that 10-foot diameter is between the house, and that's something that should be done engineering-wise. There should be something there that, you know, defines the 10-foot
So-
mark.
If I'm,
But I think the first thing to do is give the abutters a
Yeah,
chance to.
not that I don't want to hear the
make a comment.
abutters, but just a question. So if we're discussing this and we're thinking that it's an insignificant change and it's okay, you're saying that there might be some other conditions put on, I guess it's not conditions because we're not voting on something, but there's other, I guess, to sign off on the fact that it's insignificant, there's other concerns that should be taken into account if we're signing off on that as being insignificant.
That's it, because there's certain things that presently haven't been properly done.
Okay.
And I think we'll see what the abutters have to say.
Yeah, and this is not a public hearing, but I assume you don't have any objection to us?
Not at
Okay.
all.
Are there
Do you want us to go back into the audience?
No, that's fine. They can, I think the woman in the back rose her hand first, so. Okay, you want to come,
Mr. Challen, you have to use the mic, please. Over there.
This mic? Good evening. I'm Roger Challen, 29 Oak Hill Road, one of the, I guess, two abutters that are on the southern side, and really the only residential abutters, I believe. I think Walgreens being the other one. And I'm a little hurt that Mr. Kablak didn't also apologize to we abutters who were also hoping, well, maybe that's not fair. Not looking forward to seeing you again after the 3 years after the 3 years we sat in all of the public hearings along with Mr. Bartolini. I don't think the other current members of the ZBA had that pleasure. I have a process question because I don't know a lot of the zoning rules. And then I have, I guess, a follow-up question. My process question is related to the issue of discussion versus public hearing. How is something determined to be a discussion versus a public hearing in the first place? Because I think that as a discussion, no notification is required for the abutters.
It's under the rules and regulation of mass housing.
I looked this up beforehand, okay? I'm not saying the rule makes sense, but Lee is right. There are regulations that govern the whole 40B process. There's a particular one that says if after the comprehensive permit has been approved, someone wants to make a modification to it, change something that's depicted, they submit something to the board in writing, then we have to act on it within a certain time period. And then it says later, if the board determines that the change is a substantial change, comma, it shall hold a public hearing within the meaning of chapter 40A, et cetera, et cetera. So that kind of infers that a public hearing is not required when we're just dealing with this. But it's helpful to hear from you anyway.
If you remember, Mr. Challen, that when we originally approved this, it's written into the decision under the mass housing that it would be interviewed and 20-day approval, and if it was something that was not accepted, that it would go then into a normal public hearing and start over.
My issue wasn't at all to kind of object to the regulations, but as I understand it, this decision could have been made with no notice, with we abutters not knowing anything about it. And that's the way the process works, even though the change is something that's going to be in the view of the abutters and things like that. But I just want to kind of understand that this is a change that could be made without the abutters knowing anything about it, according to the law, and also, I presume, according to the way you folks kind of proceed.
I thought about that question. I mean, I think you're suggesting that on something like this, even if the law doesn't require it, the abutter should be notified. And
Just as a courtesy.
I understand. So I thought about that. The question is, okay, so if we do that, which noters do we abutify? How do we notify them? Who pays for it? Maybe I'm thinking about this too much legalistically, but
I thought it was understood the building inspector would do it.
yeah, I understand that he somehow, you guys are here, you learned about this, and that's a good thing.
It's not really the question. It's that, we happen to be here by luck, but I just want to kind of understand that the general process is, yes, this could be done totally, I'm not using the right phrase, but let's say behind the abutters' backs. I don't mean that the way it sounds. Without the abutters ever hearing about it. It could simply be changed and approved and gone forward. And I guess the law is the law, but I'm, kind of courtesy is, in our town, I think is something that we pride ourselves on.
And whether it's even a phone call to somebody, there's only two abutters, and whether it's even a phone call to say, by the way, it's not something you have to do, but it just seems like that, the nature of our town would suggest that it would be a nice thing to do. So we are here totally by luck, and disappointingly, not because somebody at least gave us a heads up. And now I understand that that's what the law says you can do. But there's nothing illegal about somebody giving us a heads up, right? That's not something that Mr. Heavey or Mr. Kablak could legally come after anybody for doing, is just sort of letting us know.
And there is something in the decision that we did,
The decision or the question of process?
our decision that we did in us making a recommendation to the abutters if there was an issue or something. And honestly, it's been so long, Roger, I forget what we actually wrote. But there is something in there stating, and I thought it was written that it was the building inspector's responsibility to do if something was coming back in front of the board. Because there was a discussion at the meetings about that.
I recall something like that, and that was why I was asking, but my question was really the opposite. There's certainly nothing illegal that the town would kind of run some sort of a legal risk against Mr. Heavey or Mr. Kablak, his attorney, as far as giving us a heads up. That is something that could have been done without violating any rules or laws. Is that fair? Just curious.
Yeah, I think that's fair.
Okay. So one of the things now, because this is a discussion and nobody really knew that the abutters were going to be here, and there's a lot of conversation about the plans and the changes, we can't see them, and maybe we don't have a right to see them because this is a discussion. So the things that are going on with the change have been discussed. I don't think there's any way we can comment on that because we don't know what they are. Typically, I guess it's more of a hearing situation. You have the plans, up on the board. Everybody can see them.
Let me explain.
Yeah, okay.
And it's kind of an open and, kind of a dialogue between
All right,
folks.
Roger, the change is very simple. What it is the existing plan of number one, the house facing Route 9, the northbound set south, is the two extra garages are setting out 12 feet more, is that what they are? And originally, those two set-outs were in the back of the house facing your property.
6 feet more.
So the new houses, the back of them facing your property and the other abutters are the flat wall. There's no deck, just a little walkway. And in front of it in the garage, and if you drive by it, you'll see the indentation in the middle of that building that just got put up. And that's the only difference in the plan we have.
So again, I'm trying to visualize it because I'm not so good.
Ask for copy.
Well, I think if just not just me,
Okay.
do you have 4 copies or?
Yeah, but if you look at the building that's there,
Okay, so quick question as I'm trying to visualize this. You talk about the setback issue. So there's a 10-foot setback in the originally approved ZBA plans. The deck came up close to the 10 feet and the steps kind of came down 1 or 2 feet over the across the setback. Is that fair? No?
the original plan drawing was that the main building,
Right?
the whole back of the straight building,
Right.
was 10 feet from the property line.
Right?
The deck is in between, which, Mr. Martin, how far out is that deck in the front?
6 feet.
So it comes out 6 feet. So the building is out 6 feet, and then in the middle, there's the deck. And off of that, which is 10 feet away from the property line.
Off of the
that.
deck.
Right, and then there's just the walkway.
Yeah.
And now it's turned around, and the back of the building is completely flat
And
against the property line, and the only thing are the stairs.
Against the
that go.
setback.
when I'm okay, go ahead.
Against the setback. So the back flat of the building is not against the property line. It is still 10 feet away from the property line.
But again, back to and I may have missed it, back to the original approved plan. What came up to the setback? The wall or the deck?
The wall
And the deck.
and the deck was within the 10-foot mark, but not the deck.
You got a couple
It's two
stairs.
different things here. We're not talking about decks in the back.
Mr. Kabak,
All it is the set of stairs.
Mr. Kabak, the what is being requested right now is what you're saying was approved, actually.
What was
I
discussed,
think that was the
requested by,
intent. Yes.
Is- And was
So
that,
what they're asking for us to determine is a insignificant change. Again, I wasn't on the board back then.
I understand.
If I'm following it correctly too, what they're asking for us to determine as an insignificant change is what was actually approved,
Originally.
or what was
Yeah.
actually originally
It was
approved.
approved.
So I'm
just
not
wasn't
hearing that. I
filed.
didn't hear that initially. At least Mr. Barnolini, identified that we approved something. So if we approved something,
Actually, he said the
then-
original plan, not
but the
necessarily.
original
See, the
plan
thing
was,
is-
the original plan was approved, then apparently the applicant took a plan to the building inspector that was different than was approved.
Correct.
Correct.
In the middle of the process.
Correct, and that's why the building inspector said, if I'm following this correctly,
Right.
I can't allow this because that's not what was approved.
That's
not And what it-
recorded. Like,
Not
It's not what was recorded. They actually approved it as it is.
They recorded the wrong
Approved
plan.
the right layout, but recorded the wrong plan.
correct.
Inadvertently, the wrong plan was recorded than what was approved.
In the beginning,
Now,
in the process, we approved the original plan, which had the deck on the backside of the property. And
The backside
what-
being the side facing,
The abu-
on the butter side, I
property
got
of
it,
the
I got
butter's
it,
line.
I got it.
Then one of the members of the board, which we had a thing where we interviewed the inside of the buildings and everything, made a recommendation that they redesign the building. And in doing so, that they put the porch in the driveway side of the building, not in the, against the property line. So that was the change in the approval that we did. And then the back, so the only thing that's there now are the steps, which were there, except for the porch, which is indentated into the house, flush, is now in the garage side.
Okay.
And I
But we
just-
did approve it. It was, originally, we did it with it on the property side, and then we rechanged it during the process and put it in front of the driveway.
It actually moved the building 6 feet further away, which is where it is now. The other way, we would have had those push-outs going into the 10-foot setback, and there would have only been 4 feet
That was the full
of
footage.
back
Okay.
line.
so there's the woman in the back has been waiting very patiently. Now she's saying that,
Right.
Are-
And these are what
do you
they're
wish to
building,
speak?
But supposedly, the insignificant changes.
What else-
So,
Excuse me, sir? Maybe, I just want to give this woman an opportunity to speak. She's got to speak at the microphone, so why don't you
Well, no,
just...
just let her have the microphone, you can stay there. I
Yeah,
guess.
yeah, you can both go, you can both go.
Hi, I am the abutter, the only abutter. I'm Alice Russell, 15 Oak Hill Road.
Thank you.
And our question is that when the plans were originally approved, all the meetings that we went to, our understanding was that the homes were going to look exactly like the homes that are on Oak Hill. And it appears that the new home does not look like that.
You mean the ones that face,
Oak Hill Road.
okay, instead of the
Main
ones which
road.
face Fayville Lane?
Yes, the one that faces our backyard. I understand that it was switched, it was turned, but also the ones next to us facing Oak Hill has 2 windows on those protruding areas that they're talking about with the porch in the middle,
Yeah, kitchen, eating kitchen.
where the kitchen is. There's 1 window above each one of those, and only 1 window on the side of our house, which is a small window. It appears that it's over their sink. So our understanding was that's what we were getting the next house. The next house has, facing the middle of the road going in, there's 2 larger windows above that bump out.
Same area, yep.
They're much larger, and there's 2 of them. And then there's 4 windows on each side, and there's 4 in the back, plus 2 sliders on each end. And the sliders look about a total of 6 feet. So to accommodate that 6 feet, there would have to be some kind of a platform. I understand you're saying it's 3 feet, but it would be 6 feet in length, and then stairs going down. It's just a lot different than what we were told it was gonna look like. What our understanding was, it was a mirror image of the other two, and it is not. And we are literally right on top of this property. And our other understanding was that they were gonna do a retaining wall, and then on top of the retaining wall were gonna be trees, like what is on the Walgreens side. And the last drawing, and then when I went into the town, they said, no, that has changed, and it's gonna be a dogwood and like 2 small bushes. And then on the other end of the house is a dogwood and 2 bushes. Plus, there were trees that were taken down, and there was a discussion that the large one was ours, and it went back and forth. And Mr. Heavey ended up taking it down, but along with that, there were a couple other trees taken down, and one was completely stripped. So our concern is the remainder of what was on the tree, whose are they? And if the roots were disturbed, then what? And then we have no buffer for noise. We have no buffer for how close the neighbors are to our house. If we were to ever add on to our house, going back, which was originally a thought, this was a home that was in our family for 90 years when we took it over, and we completely redid the house with the idea that we weren't having something like this next to us. So then when this came in, and it was told that it was gonna be exactly like what's on Oak Hill, was one thing. But now, if you were to walk the property, the house looks completely different in that it has many more windows, sliders, it's turned around, and our concern is that there's gonna be no buffer, no kind of buffer for us. And when are the trees gonna go in, and how high are they? We don't want saplings if they're gonna go in. We would like some kind of privacy there. So that's our concern.
So, Mr. Heavey,
I'd like to respond.
Well,
Yeah.
well, let me, so I appreciate all the concerns, but some of these concerns were the same concerns articulated in the comprehensive permit. The comprehensive permit's been issued, and there are no restrictions regarding where the windows go or the size of the windows. I mean, it doesn't get to that level of detail in terms of architectural styling. There is a landscaping plan. We are required to meet the landscaping plan. The landscaping plan was signed by the board. We're not asking to modify the landscaping plan. To Mr. Bartolini's point, to address some of the concerns regarding screening and noise, I would advocate to my client that he put the fence in sooner rather than later. The fence is shown on the landscape plan. The fence will separate the property from the resident who's speaking now. That might help address some of the concerns. But a number of the concerns raised just now really deal with elements of the project that were discussed going back to 2007.
I understand it, we're starting to stray a little bit from what's immediately before us. I was just thinking that, I'm sorry, I forgot your name.
Alice Russell.
Mrs. Russell is here, and she has a concern, and you're here. Is there any way we can just?
Could I just make one comment? I was requested, Mr. Bartolini got involved to kind of compromise, work in the middle on this thing. The tree that was removed was not on my property. It was half dead. It was on Miss Russell's property. We had it surveyed to make sure, the survey stake is right beside where it was. I was asked by the building inspector, and Mr. Bartolini said he would assist me in finding somebody to do it. The tree was leaning onto their property. There's a shed there. It would have taken the shed down. I think Mr. Bartolini will agree. I took it down as a courtesy. It wasn't necessarily cheap. It was a big, big tree. We spent a lot of time because we had to get the stump and everything out, and we did everything we could not to do anything, even though it was their tree, that would damage their property. We took the stump out by sawing it down and one man cutting into it and chipping it out. It was a long process. That wasn't to my benefit because the fence is going to go across the front. That was on her land. The tree absolutely would have fallen because when they built the leaching field, They've raised the elevation significantly to put a leaching field. That leaching field, over time, is poisoning the roots of the tree, or was poisoning the tree. I did that as a courtesy. So, and she wanted it. She was very aggressive to coming to the town about it. And to stand here now and say she lost her shade, it was a request to remove it. The trees that she's talking about that might have gone with it were sucklings that came off the tree. And there was no way they could take that tree down without possibly damage. And she was told of that by me at her front door before I had the tree company come in and do it. So, I mean, I'm willing to go, I don't mean to sound aggressive or anything, but I went out of my way to try to be a good neighbor, and Mr. Bartolini is aware of it.
I think the process that we have in front of us tonight is for the general location, direction of the house. The issue with the windows and the other things, if you want, you need to talk to the building inspector about it and have him look at it and review it, and then if it has to happen, he will have to send them back here in front of us again, and it'll be something we look
My only
at.
question is, and that is fine,
And, I mean, I don't remember the exact drawings from
and
way
that's
back.
what, I don't think anyone knows, because they changed so many times, and the last meeting that actually the whole neighborhood seemed to have attended and signed off on was that it was gonna be a mirror image of the two in the front. And my question would be, if you look at the front of the house on Oak Hill, and then you look at the front being the part of the house that faces the driveway going in, it appears that the house is bigger, because I don't know how you could accommodate the window width
The
in
dimensions
each
are identical.
where it overhangs, because there's a small window and not much on either side, and now there's two larger windows with room on each side. It just seems like the whole building is
One
bigger.
question, Mr. Heavy, is it the same dimension
Exact same dimensions.
as the existing? Because I
Exact
did look
same.
at the other plan, and it does show that the house is the same foundation as the first two that are on Oak Hill Road. It doesn't look it, but it is the same footage direction.
Could, at some point, we see that and see
What?
that,
Well, that should be on record, no?
Yeah, shouldn't that be with the building department?
That should be on record, and I mean,
Yeah, it is.
and I understand what you're saying and what your concern is,
And just talk to the building inspector.
but I agree with Mr. Bartolini, what he's saying, or fair recommendation is that I would speak to the building inspector and ask to see the plans, ask to see the full comprehensive plan, and then if there is some thoughts or questions or concern, that I would ask him to, to verify, what the concerns are. Like if you're saying you think it's bigger than it should be due to the window size, then, I would ask,
well, it's a completely different look than the one on the,
yes,
on
and
the
again,
main
I mean, again,
street.
not having had the benefit of sitting on that,
Right.
to know what was
Right.
approved and wasn't approved. I mean, I mean, the whole comprehensive plan would be, would be filed and would be on record, and I would, I would ask to maybe, review that and again, ask the building inspector.
So is the aspect of the slider then, what is coming off that slider, and how long and wide is it? Because the slider appears to be about 6 feet. Does that mean the steps going down will be 6 feet and, a platform in front of the whole slider, and then stairs to the side? What way is that gonna go?
It's just going to be 3 feet roughly, and it's going to go straight down.
3 feet in length, or 6 feet in length and 3 feet wide?
It's 3 feet wide.
So there'll be nothing on one side of the slider?
Correct.
The fixed side.
So just where the sliding
Just
door
the door
is gonna
side that's
be
gonna go down along the
3
building.
feet wide steps,
Along the building there.
right? Because one door is
Which-
obviously fixed
And would that have been?
in the plan.
So that
would
was
have
the
been in
original-
That would have been in the plan?
The original
Yeah.
plan.
Yeah.
So like as it's showing here, if that's what would have been in the plan on this,
When we originally did it, we had the building so that those kickouts were going to be on the back. This was original, and we would have had only a 4-foot separation from your butter's land to this. At the request of the ZBA, we pushed it back on the front, actually, instead of a 15-foot setback, we made a 17-foot setback, which was, it doesn't sound like much, but in this case was very difficult. And we flipped the kickouts to the opposite side and put the porch there, and that was requested again.
That was the reason why it was done. It just
Is
a
that
matter
what,
of the wrong
is that
plan
what
that's
those,
submitted.
I know it's far away, but on this plan, is that what those steps are showing there? This shows a little bit of a,
I'm half blind as normal, so we can see that.
is that what that is showing right there, those are the 3-foot steps on the side?
Well, they're not steps, but that was,
I have my phone.
steps attached,
That's what would have been, that's what would have been there.
Roger, Chairman.
So that's what's, now that
It should be
one's
selected.
that's what will be off there now. Okay. So I
It's
think
selected.
they're kind of- I think that's kind of answered, because that is the 3 feet on each side of there.
I think the thing to do is just let them approve this. and
Yeah,
let
I want to
them
wrap this up.
Right?
Yeah.
Clean it up.
I mean, for clarity, that these items are really
Yeah, so,
building
ju-
inspector
just,
and the
just
plan.
I know you're talking here, but, so, I think your point is well taken. You know, what you came before us with was a request to, modify the approved plan, to correctly depict the footprint of the side duplex units, just reversing the direction of them, and the issue is that a substantial change or an insubstantial change, okay? So, the rules actually give examples of what's a substantial change, what's a not substantial change. Examples are substantial is increasing height of buildings more than 10%, increasing number of housing units proposed more than 10%, reduction in the size of the site more than 10% in excess of any decrease in the number of housing units proposed, a change in the building type like garden apartments versus townhouse high-rises, change from one form of housing tenure to another, things that aren't substantial, reduction in the number of housing units proposed, decrease of less than 10% floor area, change in the number of bedrooms within individual units, change in the color or style of materials used, etc. So with that,
So,
I think we've got what we need to
right.
decide this. Does anyone
It-
feel differently?
No, I mean, based on, that was the one thing I thought I should have asked you earlier, is defining substantial versus insubstantial. It certainly seems like it doesn't meet the criteria of a substantial change. And clearly it's not right to,
Doesn't or
yeah,
doesn't
I think
not?
it does not meet the criteria of substantial.
I agree.
I'm saying,
I agree with
I
you.
believe it's insubstantial.
Okay. So,
So with that, Mr. Chairman, what we'd like to do is have you, if you agree to grant the insubstantial change, have the board endorse a plan that shows the correct footprints, and that I would then record that with your notice of insubstantial change.
okay.
That will then become the plan of record for the building inspector.
And, this notice of insubstantial change written up as a decision would clarify that, my concern is have you submitted to that before? Did you submit the plan to us before the hearing?
It's the paper print that I submitted tonight.
Okay. I get it, okay. I just have in mind having a decision which clarifies the only thing that we're voting on is just the change in the direction of units 3, 4, 5, 6, 7, 8, 9, et cetera, up through 14. Okay?
Is the plan something that our consulting engineer should look at before we
No.
sign it, to make
Plan's
sure there
the
hasn't,
same. Plan is the same, but
to make sure
the
there
only
hasn't been
difference
any
in
other
this plan is
changes?
the house is turned around. That's it. It's in
Well,
the same location,
yeah.
it's just flipped from inside to outside.
I understand your question is, okay, is there some other change in that we're not aware of? But if we have a note, if it's accompanied by a decision which says, the only aspect of this plan that we determined to be an insubstantial change was the change in the direction of units 3 through 14 on the exact same footprint. So then even if there was some little difference, I think that would make clear that, no,
Gavin,
that
can you-
wasn't approved.
Right.
Okay?
That's the original plan that we approved. This here is the same plan. The only thing is, the units flip.
I get the concept, but, you know, I'm not sitting here doing takeoffs to make sure that they haven't changed anything.
What?
I'm not doing takeoffs to make sure that they haven't changed any.
Question?
Yes.
So just to clarify, what I heard you say, Mr. Chairman, you're specifically approving the change to the position. If there happens to accidentally or inadvertently be other changes on that plan you're now looking at, those wouldn't be something that you're approving. And there's also an assumption, because I heard it from the applicant, that the actual size of the units are the same as the ones that have been built.
Yes.
True? So I'll retire. By the way, I'd like to thank the board for allowing we abutters to speak, even though I know there is no legal requirement to do so. So we would like to just express our appreciation to you for letting us do so, and also to mention that if there's something like this in the future and somebody wants to give us a call or have the building inspector give us a call, we wouldn't object.
Okay.
Thank you for
Point
coming.
noted. Okay. This is the Mylar.
Andrew?
No, it should be a permanent.
Yeah, we need a motion.
Yep.
We haven't had a motion yet, right?
No.
Well, we're not, it's not.
Do we need one as a
It's not a,
We need a motion to
motion
approve that it's insubstantial.
accept
the changes
I make a motion that we approve it's insubstantial.
Okay.
But we want to make sure that that the changes of flipping the orientation of units 3 through 14
with the condition.
Yep.
is the insubstantial change that we're agreeing to.
There are no other
Yeah. Now, Joe, would you be writing this up?
Yeah.
Okay. So what we're thinking about here is a, notice of decision on insubstantial change. It's going to recite that we had a meeting and we decided to accept that the change in the direction of the units as depicted in this plan we were given is an insubstantial change, and that those are the only changes to the plan that we're approving as insubstantial change. That's it. So,
agreeing that are.
Agreeing that there are,
Okay.
there are no other changes.
And excuse me, before you make that final, because there has been a change in the window layout, it affects the privacy of our home. Could that be looked into before this is a final agreement? And we could have a final floor plan to see if there's a difference in size?
That would have to be something that would have to be submitted to us by the building inspector.
But
Yeah,
could that be
this doesn't
done
really
before
affect
there's
this.
That
a-
doesn't affect us.
That would be a different appeal. So this is just about this. If that's something that wants to be brought up, you'd go to the building inspector, they would then bring it to us, that'd be a separate appeal.
Okay.
Then we would listen
Talk about
to,
it again.
If
and more than likely, it would be something that would
whatever's
require
been
an open.
recorded as a comprehensive plan, if the building inspector feels that that is not in compliance with what is recorded,
Yeah.
then they will get a cease and desist, and then it will come back to us to have to be remedied
On those topics.
on those topics.
Okay, because like I said,
Okay.
what we thought we were having is 4 windows in
Yeah,
the
we
back,
got-
and now we have,
that's what I thought.
Right, and so like, we don't have the benefit of knowing what was
right.
done that, but the question before us is the orientation of these units, is that substantial or insubstantial? And, we feel that's, insubstantial.
Okay.
But other items we'll take up with the building inspector. to
I
find
will.
out if
Thank
it's-
you very much.
Okay, are we ready for our motion? Someone want to take a stab at it?
Do we need to make a motion?
Yeah, we're taking a vote.
Okay. I'll make a motion that the, I guess the orientation change proposed for unit 3 through 14 is insubstantial.
And that none of the other changes that might be reflected on this new plan that we were submitted.
There are no other
Yeah.
changes.
Okay, and we're just
Dated
verifying that.
9/23/16.
Yeah. What,
Second.
okay. Did you get the mo? Lee Bartolini seconded. Okay, all those in favor?
Aye.
Very good, thank you.
Okay, thanks.
We'll pick up the plan at a later date.
Yeah, and I think we have to make a decision within 20 days, so I guess Joe will give us a draft decision, and then we can look at this later tonight.
Yes.
Okay?
Andrew?
Yep.
You have to change what you did, because the first thing you did, you have to close the meeting and then do a vote.
Okay, but we don't have, this isn't a public hearing.
No, but it's a meeting. So it's gotta just.
Yeah,
Now
I don't think we have to close the meeting.
close the public.
Wasn't a public
Okay, well,
For this.
I don't think it's necessary, but sure. If
Whatever.
you want to make a
No
motion to
problem.
close the.
To close the discussion? I make a motion to close the
What
discussion.
about a
That's all.
5-minute recess so that I can get a drink of water?
Second.
2-minute recess.
I vote against that.
Okay.
I'll make a 2-minute recess.
I'm for it, go ahead.
All right,
I've
I
also
second.
voted
All right. Let's have a motion for a recess of any length of time.
Agreed.
Okay,
Lee for 2 minutes?
Yeah.
And who seconded?
The recess?
2 minutes.
I voted against it.
okay, all right, enough kidding around.
I got my water right
Okay,
here.
I'm gonna move that we take a 5-minute recess, okay? Is there a
Second.
second? Okay, all those in favor?
Aye.
Okay, we're resuming our meeting, and there's two remaining items that we have on the agenda. The first is a discussion about, there's a vacancy on our board right now. We have two alternates, and we have a vacancy on the full board because of David Eagle's resignation. And at least, when I've been here, our practice has been that we make a recommendation to the selectmen, and that we typically recommend that one of our alternates be considered for the position. And I think we should do that here. Ultimately, it's the Board of Selectmen is the appointing authority that decides it, and they can decide to accept one of our candidates or not. But I think it's appropriate for us to make a recommendation. So.
It's always been done that way.
Yep.
And
So,
the normal process is the general alternate is normally the recommendation made by the board.
you mean the most senior alternate?
Senior,
Yep.
senior alternate.
Yep. So, that has been our practice, and there's certainly a lot of benefit to that. The one thing I just want to say is I think Mr. Williams has really made a pretty extraordinary effort and contribution so far. Mr. Williams actually had planned to travel to Asia today and had changed his plans so he could be here for this meeting, even though he didn't necessarily have to attend. And I know that he already has been interviewed by the Board of Selectmen.
Who's that?
David Williams, who's right there.
Yeah,
Right
but
under-
Jeff,
Actually, twice.
Jeff Walker is our
Yeah.
senior, and Jeff Walker has reapplied for the full-time position.
Yep.
Because didn't apply for it last time. He didn't, but he's now reapplied for it again for a full-time position.
So, it's always difficult when there's, you have two alternates who you both like them a lot. So I just wanted to open this up for a discussion among the board about how you'd like to go on this. And I know David is sitting here, but this really is just an issue among the four full board members now,
Well, the reason we did it the other way, that made it easy.
to just appoint the senior alternate.
Just to take the senior
Yep.
alternate and make it.
And
Because the major legal issue for the zoning board is the fact that the alternate, the way that it's been handled and everything, is that the senior alternate has more experience and entertains more and knows more about the regulations and of the board. And that's, for years, it's always been done that way by the town.
And I know that I kind of benefited from that myself. That's how I became a member. So go ahead, if you want to jump in, Paul.
And so I didn't look at you today.
Yeah, exactly. Just like it was planned.
To be honest, I'm quite happy with both alternates, so either one I would like to.
Well, that's one of the things we could do, is we could just write a letter that says, we make a recommendation that the Board of Selectmen consider one of our two alternates. They're both great, and I think the board already has scheduled interviews for next week.
I would hope that the Board of Selectmen would consider one of the two alternates that we do currently have sitting. I think they're both very qualified and have both been dedicated and have both contributed in significant ways.
Is that a motion?
A motion well, Craig, do you want to weigh in on this? I know this is like your first full meeting, and now you're being asked to pick among two alternates, or maybe the way to not pick is we just ask the selectmen to consider both of them.
Do you agree?
I think probably the fairest thing to do is just say either of our two alternates from our perspective. I think public perception-wise, I know in the world out there of Southborough, there's a question as to how many real estate professionals are on this board, but that ultimately is the Board of Selectmen's decision.
That is.
So, and one of our two alternates is professional real estate, and the other one isn't, and we'll let the selectmen weigh that option.
Okay, so is there a motion?
Yes, I move that we give our recommendation that either of our two current alternates are fine selections for the full seat on the ZBA.
I'll second it.
All those in favor? Okay, so what I'll do is I'll make a note to myself to write up a letter. Just to be very plain vanilla. I'll address it to the Board of Selectmen, and they'll receive it, and their meeting is next week, and then we'll have a new member soon.
When you do the letter, you give a draft to the board.
I will do that.
Thank you. All of you.
So the next item on the agenda is the, I don't know how many of you are aware of it, but there's a special town meeting on October 18th, I think. And one of the things which is on the agenda is basically a change in the bylaw to prohibit the ZBA from granting use variances. Does everyone know about this?
Yes.
Okay. So, I just want to share my position on it and see what other people think. I'm not in favor of it. I think that I looked into it. The statute says you can do this or you cannot do it, okay? So it's not a crazy change to suggest that we change the bylaw so that the ZBA can't grant use variances. They are an extraordinary form of zoning relief. They should be very rarely granted. But I think that, we can exercise our discretion properly. And I think there are some particular situations where it's good to have that flexibility. And the one thing I'm thinking about is the 84 Main Street thing that came, I was just an alternate, I just observed it, but the Burnett House matter. We granted a use variance to permit the applicant to operate a bed and breakfast. We had all sorts of conditions with it, and there really hasn't been any criticism of that, and I think that was appropriate, and we would not have the ability to do that. So, anyone else want to weigh in on this?
But on that matter, didn't we also deny a use variance to allow retail operation there?
Yeah, we have denied, for example, Jack Bartolini came before us. He had, before the application that got approved, okay, which I think I voted against that and the 4 other members voted for it. So it was a special permit, okay? Before, this was on the site of Parkerville and Southville Road. There was some type of a kind of strange request to say.
To bypass the 2-year requirement.
Exactly.
Yep.
Okay, so that was not approved. So
Jack wanted to have the 2-year requirement waived when you convert from
Single
Single family to a duplex?
yeah, I'm not saying it right, yeah, and you have to have it built and up for 2 years, and then you can go,
For the
Convert it,
duplex.
and then come back, and Jack wanted to have that 2-year waived, because that was gonna be his intention, and let's skip the formality and go in and have it done, and it was a very, I guess, a very normal, request, but that was denied because, that's not the, wasn't the, there wasn't the process, and it should have been. There's other ramifications behind it, in future objections that may arise from it. So, we did not waive that 2-year. So there are things that we.
So Andrew, let me just ask, if we don't have the power of the variance, what would an appellant, how would they, what would
Sure.
that route be? To
So-
go directly to town meeting?
yes.
Okay.
And, I can see the pros and cons of that too. But, I'm just thinking of the Burnett House matter where the
Right.
property owner, he had a approval to just knock the whole thing down. And, there are times where we feel like the developer kind of has a gun to our head in terms of they have a right to do this other more aggressive thing, but then there's an application for a use variance.
Right.
Abutters are always notified. There's rights of appeal. But I think that, the public concern that has been expressed about the board being very careful in granting zoning relief is well taken, and that this is something
Right.
that should be very sparingly done.
And I believe our council has advised us on that and reminded us of that numerous times also.
Yep. So, Craig, do you want to weigh in?
I'm also against it. I think it drives the need to very explicitly define uses that could be part of and acceptable for the town to be a part of our zoning bylaws, which they're not currently, which really could handcuff anything going on anywhere in town and require it to go to town meeting, which I think is a process that most businesses, if they wanted to come to Southborough, would not sign up for. They would just go to a different town.
Lee?
That's a major issue, in which is what he's saying. And the issue is due to the fact of construction and the way Route 9 is right now, and things have got tight and everything, there's more use variances available. The other thing is, if you go through a use variance and have to go to town meeting, most people, developers, won't do it. They won't waste the time and do it or anything. In the past 8 years, use variances that have been granted by the town have been all approved by abutters and have been done. It's been 14 years since the board has lost an appeal of a use variance approved by it. And we've also raised $3,280,000 a year in tax revenue for the town of Southborough by approving use variances. Where if the article did get denied, that would be something most likely that would go away. There's no question about it. And the thing about the variances, since I've been on this board, we have not had a variance that's been complained about by abutters and everything that's been approved. They've been denied. So 99% of all of our variances. And just so everybody knows, because I know what you people are thinking of, the use variance in Park Central, only one abutter got up the night of approval and complained about it. Only one person was at the meeting and complained about that approval. Okay? So all our other ones that were done were approved and everything. So the thing is that, and I want to say 7 or 8 years ago, this went to town meeting to be done again, and it was lost. It was not approved. And most likely, I hope it, and don't think it'll get approved again either.
So,
I'd like to add that, you know, one of the things that people don't see today is what innovations are going to come 10 years from now, and what types of things are going to be presented in front of a municipality of a business or something along those lines that hasn't even been thought of yet. And if there's no way to accommodate that except through town meeting, then it really does put the town at a disadvantage.
And most of our abutting towns do have their use variances. There's some without it, but the majority of our abutting towns do have the use variances.
so it sounds like we all agree. The reason I put this on the agenda is, I'm planning on attending the special town meeting, and even if I was just a private citizen, I was intending on going up and saying a couple words about how I felt on it. But do you think that we should, again, we could just take a simple vote that the ZBA does not approve of the citizen petition to change the bylaw about use variances, and it's just our official position, and then I could state that.
Yes, we do have the right to do that.
I would be in agreement with making a statement of it.
Okay, I have no idea how this is going to turn out. I think it'll be very interesting at the town meeting. We'll just have to see.
The thing that the people want to think about, that when you go to town meeting, you bring your family, because we need 2/3 votes to get it approved. So anybody you think about to bring it, go, because it is a major issue for the town of Southborough, and it will affect us for many years due to the fact, especially tax-wise.
So to make a change to the zoning rules requires a 2/3 majority?
Yes.
Yes,
Okay.
it does. And the last time that it was done, I mean, it won with no problems at all. It just went through real easy. And that was and it was that year, I want to think if I remember right, it was recommended by the planning board. They're the ones that had made the submittal and did it, them. Pretty sure that's the way it was back then. But I will make a motion that the zoning board approves not to grant the condition of a use variance at town meeting. That's the way to say it?
How about,
Approve
about-
our chairman making a statement regarding our position on,
About support or not support the
Our- yeah. petition. our position on the use variance,
I'm not supporting it.
yes. which-
Okay.
is there a second? Well, first off, was there a motion? You want to say it again, Craig?
Sure.
Go ahead.
I move that we designate our chairman to stand up at special town meeting on October 18th, 2016, to state this board's position of disapproving of a change in the ability for the ZBA to grant use variances.
Also, I would recommend that we write a letter to the Board of Selectmen prior to that.
Well, on that, I think we may have already missed the boat because I think the Board of Selectmen already had a meeting on this.
They did, but we still can send the selectmen a letter, so they have not, and Mr. Sabino can correct me, but they have not voted in favor or against it yet, have you?
I think Mr. Semino has taken a vote
Have
against
you
it.
guys voted in favor or against it yet?
Board of Selectmen has not taken a position on
That's what I thought. They haven't done it yet,
Okay.
so,
I thought,
no.
okay.
May I just suggest your very simple motion is to not support the article? That's the text of your motion.
Makes sense. Okay,
So moved.
second.
All those in favor?
Aye.
And the other thing is, Paul, Andrew, that
Yes.
any of us have the right to speak at town meeting on this article,
Sure.
As an individual.
as a board member.
Oh, as a board member?
Yes.
Well,
Well, you want to make that so it's agreeable?
how about this?
I mean, they all.
Whoever
know
speaks,
Yeah.
we voted as a board that we don't support it. That's it. So
Right.
you
I
can
mean,
say
that-
that. You can
that-
say that at the town meeting.
The
At the
general,
You can say whatever you want,
Right,
Right.
okay.
but we are authorized to say that the position of the board is blank.
That's your job.
yeah, no, I think to Mr. Smino's point, what typically happens there is the boards either support or not support the motion on the floor. And you just keep it that simple. If we speak as individuals.
Okay. Do we agree that, all right?
Okay, I don't think there's any,
Mr. Chairman,
yes,
I make a motion, we adjourn.
hold on. Are there minutes? Do we have a backlog of minutes that we need to approve?
Yeah, I didn't know that you would get to them, but I've been
Could we-
sending
could
them to you guys.
We'll
We have
do it
like
at a short
The other-
meeting.
still, we have.
Okay, is there
Other
anything
issue-
under where we're under time
August.
deadline that we should approve it?
No, I've been handing them out as drafts, if
Yeah.
people have asked for them.
Okay, so,
And the
let's-
other issue we have too is we need to take, and we need to get a calendar, and we need to set our agenda for the next 7 months to June. Because we preset that every 6 months, so it's due to be done again. So that when Karen gets the thing, they can schedule our meetings, unless we have special meetings that we do in between for, applications or whatever that comes up. But our regular monthly meetings need to be set up, and that way they're agreed by the board.
okay, but I think our general plan is that we meet on the third Wednesday of every month. We've always done that.
And are
Well,
we
it's
gonna,
not, because that's normally the third or the fourth, depending on what the month is.
Andrew?
Because in November, the third Wednesday is no good,
It's the 16th, yeah.
and
That
in
is- it's fine.
December, it's no good.
No, there's 5 Wednesdays in November.
I don't have a problem with
Look at
that.
the calendar.
Well, normally what we do is we have our meeting at the end of October, and then we have it at the 1st of December.
Okay,
We've
we'll
done
we'll
it.
just talk about it at our next meeting, which is going to be on October 19th.
Okay, yep.
Does-
All right.
Does that have anything to do with deer hunting season?
The November, yeah, okay. All right,
Andrew, I
Okay.
want, just one other, are we gonna have the meeting time start at a consistent 7 o'clock? Because I often get confused what time the meeting
No,
starts. at.
Andrew can't come here until 7:30.
So you can't come to
no,
7?
I have accommodated, I've been leaving early to make it at 7, just because I think that,
Because you had asked to do it at 7:30.
It doesn't matter to me what time it is, I'd just like to
Yeah.
have it
What
so
would
it's a
you like?
consistent time, so I don't get
What
confused.
would you like? I mean, you stated before, because you take the train, that you want to do 7:30.
7 o'clock is fine.
All right, good, I think that's
Okay.
great. Karen, that's
Mr.
good,
Dennington?
right?
Yeah,
Yeah, you get
so,
a packet
the-
with an agenda.
Yep.
Uh,
good.
I just
All
had one question.
okay.
right. So I make a motion that we adjourn.
Oh, I do,
I just had a question for Mr. Dennington. Were you aware that town council is against use variances and has actually made a written note in his, in a letter of opinion against use variance? I was just wondering if
Yes,
you...
he did it the last time, too. It went to town meeting. He was against it then also.
And I also wanted to just make a
Her
comment that
question was
only...
addressed to me, and I am aware of that.
Okay. The comment that only one abutter objected absolutely is not true, and it's going to be appealed and hopefully successfully, seen through.
Mrs. Shimkus, you are completely wrong. I was at the meeting. There was one abutter that appealed that objected to
Mr.
that
Dennington,
variance.
the problem is sometimes lay people, the abutters, don't even understand the process. They don't understand that they have a time period and can object. Oftentimes, they don't have the funds, or they don't know who to hire for an attorney. So, lay people often have a problem understanding the process itself. Now that the public has caught on and understands what's happening, they do understand the dangers associated with use variances and that they basically constitute spot zoning.
I think that's a discussion
okay,
for
so,
the Board of Selectmen.
yeah,
I mean,
so-
that's not for us to
So-
be.
Give
Yeah,
Mr.
so- okay,
Semino
so-
a chance
so-
to speak.
But the
We-
point
the
was
point
about
is-
town council.
I
and hoping-
appreciate that. I answered your question.
Yes.
We all
So I
know.
think that we're not going to, this is a debate that's going to be had at town meeting, and everyone will have the opportunity to make their points there. So I don't think it's productive to replow.
But
old
certainly
ground.
town council holds weight with you, I'm hoping.
Yes.
We had a discussion and we made a determination. I don't know
Okay,
why
so-
that's of difficulty
That sounds
to you.
disrespectful to me, I'm sorry.
Well, what you're telling us is kind of disrespectful.
No, it isn't, sir. I'm making a
Very much
point
it
of
is.
process to Mr. Dennington, thank you.
And he acknowledged your comment.
All right, Mr. Semino, do you?
Yeah, I realize I need to be very clear, because words are important. About 5 minutes ago, I suggested to you guys the syntax of a simple motion when it was clear where you were going. That is not my personal position.
Okay.
In fact, my personal position is the opposite. I
That's what I
support
thought.
the article.
That's what I thought.
With the caveat that I've expressed to the proponents that, there need to be at least the workings of an alternative to address the concerns of the development community. Otherwise, I think it's an uphill battle. But I don't want to be misconstrued in terms of helping you form your motion that is in any way my personal position.
No problem.
That's
I
understandable.
realized after a minute after I said it that I needed to make that
Thank you
clarification.
for
Well, I
that.
could I could tell you knew that we were struggling to find the right words, and you found a simpler way to say
That
it.
was
So
the
we
only
appreciate
point.
that.
Thank you.
Appreciate that.
Thank you, Mr. Semino.
Okay, so is there a motion to adjourn?
I make a motion, we adjourn.
I would second that motion.
All those in favor?
Aye.
Aye.